Yes.
My lord, item number 44, order correction, my lord. It may be taken as upgraded item, my lord.
Which one?
44.
Why? Will you take in its course?
At least before rising of your lordship. Oblige, your lord.
You taken up.
I beg to mention item number 14, Lordship, 1 4. On instruction, Lordship, we may be allowed to do this. The matter has become partially infected. Petitioners are
Item number
1 4.
14.
1 4. Petitioners are the franchisee of the APTCL department.
Huh?
Petitioners are the franchisees of under APTCL Lordship. Subsequently, other communication is there. This is the, we have.
You want to withdraw
taken
your name?
APTCL.
Mr. So-and-so, the learned counsel appearing on behalf of the petitioner submits that he has instructions to withdraw the instant petition. Accordingly, the petition stands closed on withdrawal. I can't hear your voice. Something is wrong. Tell me.
May I please your lordship?
Yes.
Lordship, I beg to mention item numbers 7 and 34.
7?
7 and 34.
Yes. What is it?
Lordship, my senior who is the conducting counsel in this matter, he is not feeling well. Sir.
Huh?
He is not feeling well. My senior, the conducting counsel in this matter.
Who is appearing for the other side?
No, I know.
Nobody is appearing. Have you taken the consent? No. We'll take it up. Next.
May I please the lordship, I beg to mention item number 16. I am appearing on behalf of respondent number 5. I have to take some press instruction. I have already
Item number
16, my lord.
16.
Yes, ma'am.
Okay.
Well, matter may become next week, my lord. I have informed planet counsel for the petitioner also.
You want to take it next week?
Next week, my lord.
Why?
My lord, I have to take some instruction from the department, my lord.
What instructions?
This is regarding the slaughterhouse, some new development. This is regarding the slaughterhouse, my lord. This is.
You are there
Yes, sir.
in this matter?
No, 16. No, another.
Okay. At the request of the learned counsel appearing on for the respondent number 5, matter stands adjourned for 4 weeks.
I beg to mention item number 42.
40?
2 minutes.
42. Yes.
In this matter, the engaged counsel is outsider matter. They should be taken up after 2 weeks.
2015 matter. Orders. We'll see why the matter has come up for order.
Must.
Lordship, item number 11, I like to mention item number 11. Lordship, can you take up this matter after 1 week? My senior is out of station, Lordship.
Item number?
Lordship, item number 11,
Okay. You are appearing for?
I'm appearing from the petitioner side.
You want an adjournment?
Yes, Lordship.
At the request of the learned counsel for the petitioner, matter stands adjourned for 4 weeks.
Much of it.
Daily list item number 1.
May I please, your lord.
Yes.
My lord. Lordship, this honorable court passed the order on.
Yeah, but there was none. What is wrong with it? Yes, what are you challenging?
Lordships, this
Judgment and order dated so and so.
lordship,
3
What?
judgments you are challenging
lordship. And
in one writ petition. Why?
it is having connection, lordship.
So you
Lordship.
challenge all 3 judgments in one writ petition.
same petitioner, same respondent. Lordship, on 25/7,
Who filed the three appeals?
appeals preferred by the respondent lordship.
They prepared three appeals.
One appeal.
Huh?
One read appeal.
No. Judgment and order dated 14/3/1997 in case number 188/1995. Judgment is again, the next one is 11/5/2007 in RA case number so and so. Judgment dated 16/6/2009 in RA case number so and so. And what is RVW?
That is review petition, Lord.
Review.
Review petition, Lord.
Then why are you challenging the three in one writ petition?
Lordship, this 14/3/1997 Lordship, that judgment delivered by the ADC, learned ADC, Additional Deputy Commissioner, it was remanded back by the Assam Board of Revenue, Lordship, for taking the fresh evidence and deliver the judgment. Then Lordships, this order dated 11/5/2007 Lordship, the learned Additional Deputy Commissioner upheld the order. Lordship, then we have again filed the appeal, Lordship, before the Assam Board of Revenue, Lordship. Lordship, this review petition, subsequently it was filed by us and it was also dismissed, Lordship. And thereafter, Lordship, we have approached before this honorable court, Lordship. And this honorable court, after hearing, Lordship, delivered the judgment on 8/9/2017, Lordship. On that, Lordship, the entire case record has sent back to the learned Additional Deputy Commissioner for taking a fresh hearing, Lordship, taking into account that Bahar Ali, Lordships, he produced a medical certificate. That medical certificate, it was issued by Senior Medical and Health Officer, and accordingly, Lordship, it was remanded back. In the meantime, Lordship, this Bahar Ali, Lordship, he expired, and Lordships, his legal years, wife and 4 daughters, they preferred the appeal, Lordship. They preferred the appeal, and Lordship, that appeal, it was disposed of on 14/2/2019, Lordship, for taking a fresh hearing before the Honorable Single Judge Board. And accordingly, Lordships, this writ petition is fixed for hearing, Lordship. Now, Lordships, on 25/7/2023, Lordship, Honorable Court, after hearing the matter, Lordship, all the three records of LCR, Lordship. In that LCR, Lordship, this I have gone through the records, Lordship. These records are received, Lordship. That is, all the three records are received, Lordship. Now, Lordship, this I have to go through the records, Lordship. Now, Lordship, if the matter is taken up after a week, Lordship, in the meanwhile, Lordship, I can go through the record.
Tomorrow,
On
go to the
Thursday.
records. Tomorrow at 2:00.
I'll-
Mr. R. Sharma, appearing on behalf of the petitioner, submits that he wants to go to the records of the Assam Board of Revenue, which were called for by this court. This is the matter tomorrow at 2 p.m. for further. Did I record?
Supplementary list item number 46 for motion.
Here I filed the affidavit. This is a matter where they're seeking instruction, taking directions to the DC to conclude the hearing in our petition. There's a miss case pending with the DC, where we are seeking that certain mutations need to be cancelled. On the last day, the application was not in record, so that has been got on record by way of. And
What are you challenging?
so, Your Honor, there's a plot of land. On that plot of land, a builder was building certain apartments under a builder buyer agreement. And what has happened is that the builder was given a power of attorney by which he could, carry out certain functions, which is per course. But the power of attorney holder passed away 1 year after entering into the agreement and after giving the power of attorney. Subsequently, the legal heirs took over, but that deceased individual's power of attorney was repeatedly used for selling unbuilt flats, essentially. Just the apartments were never completed, but the shells were sold to multiple individuals, creating third-party rights. And this has been going on for a long time, and there was even a stay order that was operating during this period of time. So we brought all these facts to the notice of the DC. Subsequently, the matter was escalated to the Chief Secretary to set up an inquiry to the Commissioner Lower Assam Division. And the Commissioner Lower Assam Division found that there is indeed fraud, and even a FIR was supposed to be lodged against the builder. Unfortunately, the builders passed away, but those mutations survived. So we had filed a follow-on application where we sought for the cancellation of the mutation. This was in 2016. So we filed the application 2016, 27 for 2016, the application was filed. About a week later, the notices were issued to all concerned parties, including the home buyers. And subsequently, in August of 2016, almost 7 years ago, the circle officer passed an order saying he cannot review his own order. So he pushed the matter up to the Deputy Commissioner, the DC. And that's where the matter lays so far. On multiple occasions have been given, no reply has come from the DC. And last year, the DC held one hearing. But after that, again, the DC's no further dates have been given and the matter has gone completely quiet. The only prayer here is that the matter may be concluded one way or the other, so that the home buyers and the landowner both can have some finality to this dispute. Page 185, you'll find the additional application.
Page
185. And 189 is the application that we did for the dispute.
Without even issuing notice, the affidavits have been filed. Huh?
Notice was issued, Your Honor.
Notice issued.
No, this is an additional affidavit. There,
That's good. No notice has been issued till now.
it's a motion. That's it.
So you want this court to pass an order without hearing the other 5 to 23?
They may be heard by the DC. That's
Why?
no,
You have filed, you have made them parties.
very well. That will be fair.
Without issuing notice, how can this court at all do anything? Issue notice. Second court goes. Issue notice, making it returnable by 15th of November 2023. Mr. N. Goswami appears on behalf of the respondent number 1, 2, and 3. Extra copies of the writ petition be served upon him, along with the additional affidavit by Nikita Kumbar. by 30/8/2023. As regards the respondent numbers 4 to 23, steps be taken by way of registered as well as usual by 30/8/2023. It is made clear that along with the writ petition, the additional affidavit be made be made a part of the steps to be taken against the respondent numbers 4 to 23. This accordingly.
Like,
47,
Made future lord. My lord, earlier, my lord, the members were prevented from entering into the camp area on the alleged plea of some violation of Forest Act, my lord. Then, my lord, we challenged those actions, seizure and restraint order. And this has resulted in the judgment by learned single judge of this court, my lord, that your lordships will find at page number 175. I'll have your lordship's kind attention to my lord, 2 paragraphs
What was the challenge?
in the petition, my lord. Seizure report and offense report.
And offense.
Offense report filed under the forest for alleged violation of the Forest Conservation Act.
Hmm.
Now, my lord will kindly come to page 188. Para 23.
Yes.
That apart, this court is of the view that in the wake of the availability of number of communications by none other than the Ministry of Environment and Forest, Government of India, regarding efforts taken by the Petitioner Association to protect the environment and forest, and also for increasing the number of pasture in the hatchery, and by making awareness camp in the form of competition, the present action impugned in this 2 writ petition appears to be an outcome of mechanical exercise, which also indicates malafide on the part of certain officers of the department. The official communications also indicate that the activities of the Petitioner Association have also reduced the poaching activities. The said observation is very significant one made by none other than central government representative, which this court gives a due importance. Then, my lord, will kindly come to last page, my lord, page 190, para 30. In that view of the matter, this court is of the considered opinion that impugn action of issuing the impugn report, so and so dated 25/1/20, issued by the Divisional Forest Officer Sokipur and forwarded by Range Officer Saridwar Forest Range is unsustainable law and is accordingly set aside. The interim order operating is accordingly made absolute. My lord, as a result of this order, my lord, now there is no restraint. There is nothing. So we should be allowed to operate. Now, what they have done, my lord, the impugn order has been passed at page 191, whereby, my lord, by invoking a particular clause of the original agreement, now, my lord, the contract is sought to be discharged. My lord, it is an attempt to override the order of this honorable court. So, my lord, will kindly come to 1 paragraph. Please come to page 192, para 7. In response to these violations, a forest offense report was registered against the Abaka by Range Forest Officer Saridwar Range. Although Abaka challenged the report in WPC number so and so and so and so, both writ petitions were dismissed. These are allowed, my lord. The order I read, this is the order passed in these 2 writ petitions. And we see, my lord, the circumstances in which, my lord, this order has been passed. And most importantly, my lord, we are undertaking an activity which has been acknowledged by the Government of India, Ministry of Forest and Environment. Whereas, my lord, we have given annexures in the same division, my lord.
Mr. Story, thereafter, is written the forest offense. report.
Forest offense was set aside primarily due to jurisdictional error, with the court noting that DFO Sonitpur and Range Officer Saidwar are not authorized person under this so and so, the forest conservation rule. If that be so, then they could have initiated the proceedings by
by the competent authority. Instead of that, my lord, they have foreclosed the whole thing. In fact, my lord, if your lordship would kindly come to last paragraph, last page 193. This letter serves as a formal 3 months termination notice in accordance with clause 9 of the MOU, requiring Abaca to vacate the camp area except for maintenance of the hatchery. To address any concern or seek clarification regarding this meeting, notice and meeting has been scheduled for so. Please treat this notice as a.
Now what do they say?
Now
Can
they
you
have-
come to paragraph 8 and 9?
My lord. It is crucial to note the Honorable Court did not issue any mandamus permitting petitioner association to resume its activities in the eco camp, except for the interim order which was made absolute in the final order. The interim order stipulated that in the meantime, respondent number 4 and range officers shall allow entry of 10 persons authorized by President Secretary of. Well, this order has merged with the final order. So our impugned action was, my lord, the seizure report and the restraint order in the form of the offense report. Those has been quashed. And interim order was for no question.
What is this pursuant to the order of the Honorable High Court?
Abaca is hereby granted permission to, actually, initially, my lord, in the first writ petition, because the hatchery is there, when they put a restraint on the entry of everybody, then 10 persons were permitted to look after the hatchery. That is an interim order. So all those orders, my lord, have merged with the final order.
Oh, let us see what is the actual dispute.
Yes. My lord will kindly come to page number 26. These were the annexure 26, page 126.
Page?
126.
Yes.
Today on 1/10/20 at about 2 p.m., Sri Dharmendra Kolita seized the following property forest produce from possession of the camp, director of Eco Camp Nameri, so and so, for an offence committed at Balipara Reserve Forest under section 24 and 25 and under section 2A and A 3B of the Forest Conservation Act in presence of the following witnesses. Well, they wanted to say that we were involved in some non-forest activities, which is not correct. Then page 127 is the same, my lord, is the original copy. Then kindly come to 128.
Yes.
This is by the, my lord, DFO. In view of Royal Forest offence case number so and so on the relevant section, and as per directions received from the Conservator of Forest, I am directed to ask you to hand over all the seized item, articles, properties as per the enclosed seizure list to the Forest Department immediately to avoid any further legal action against the Eco Camp Potaka. This is for your information. Then, my lord, page 129. Regarding handing over seized item. In view of Royal of Forest offence under the relevant section of the Forest Conservation Act, the following properties articles were seized on so in your Eco Camp by range officer Saridwar. The properties which have been seized being forest properties are mentioned below. 130. In this regard, today on 25th of January, the above mentioned seized forest properties, I say Bhanu Ranjan Bora, in charge so have taken over possession of the camp, so and taking over formalities are done in presence of the following. Basically, my lord, they made some seizure and put a restraint on our entry. Then we moved this honorable court. Initially, there was an interim order.
So
Whereby,
you have challenged 129
yes.
in WPC in the writ petition.
First, in first writ petition, we filed, my lord, this
Kindly come
page
to page
126.
Yes, because page 178 says the
Yes.
petitioner has put to challenge an offence report
Yes,
dated demand which have been submitted to the court of the by
Yes,
letter whereby all
Yes.
members of the has been termed as accused against the offence dated when.
in the, my lord, first writ petition, while filing affidavit, they enclosed this document. Therefore, we filed the second petition when we challenged the offence.
Now this offence report has been quashed.
Nothing remains. And my lord, lordship will kindly see from page number 2 204 to 216, we have given, my lord, photographs of how, my lord, resorts are being operated. They do not have any problem with that. Now they have, my lord, invoked this clause.
Clause 9 of the,
Yes, original memorandum of understanding.
where is it?
Yes, sir. Page number 84. This was the original, my lord, agreement. If your lordship will kindly come to para 1 at 84,
Is
That-
it an agreement 84?
MOU, my lord, MOU.
Meeting of the so and so.
That the Northeastern Council, first para 1, my lord,
Okay.
then after effort to the NEC has provided Abaca an amount of rupees 3,92,000 for purchase of equipment for promotion of angling. Page 84, my lord, clause number 1, understanding. Was the bottom.
Now, page 88 is the clause.
Yes. Yes,
We agreed that in the event that the running of the camp becomes unviable,
unviable. Either
they
party
will
can,
be at liberty to terminate. So they have exercised this.
yes, but what is the unviability, my lord?
Yes, Mr. Burua.
My lord, I'll have to obtain instructions on this count.
Don't do any action. In the meantime. Issue notice. Making it returnable. Issue notice making it returnable by how much?
4 weeks.
Making it. Hey, এখন নতুন এখন নাইজেনে ক্যালেন্ডার কোড করে। Now the October vacations have changed, no?
Yes, well, I think it starts from earlier it was 14. I can,
Now we have till 19th of October.
yes,
I think the October vacations closes on 20.
I think up to 20 we have put or 19.
No, 20, I think from 20 it is closed.
Okay, oh, no matter what.
Issue notice making it returnable on 16th of October. Mr. A. Burua appears on behalf of the respondent numbers 1 also. 1, 2, 3, 4, 5, 6. Oh, appears on behalf
Yes.
of all the respondents. Extra copies of the writ petition be served upon him by 31st of August 2023. From the perusal of the materials on record, it reveals that on 25/1/2021, 2020 or 21,
21.
Huh?
What's it? 25, 1, 21.
20, na?
20 over. 20.
20. 21, that is
No, no, it
20.
should be 21, my lord. The
20.
Caesar list was 1, 10, 20. It is 21.
I think the court must have
Taking over report is 25, 1, 21. The Caesar was on October.
no, what was challenged out here in page 178?
1 second.
Paragraph 2.
Yes,
What was challenged?
my lord, this is the Caesar memo. But offense report is subsequent.
No, where is the what was challenged?
Before the, my lord,
Mm,
subsequent.
Earlier writ petition,
Earlier Caesar, my lord,
where is that?
at page 126.
126 is, what is the date? It is 21/10/2020. There is a communication on 3/2/2020. What is it?
Yes.
Where is that?
22.
Just find.
Page 139, my lord. Page 139.
From a perusal of the records, it reveals
এখন the court of this is how the proceeding started.
that a meeting was held on 26/1995 at the office of the Deputy Commissioner Punitpur for arriving at an understanding between the Department of Forest Wildlife, Assam, and the Petitioner Association for implementation and management of the eco-based camp set up under the scheme, inverted comma, development of angling facilities in the any region, inverted comma closed, sponsored by the Northeastern Council. In the said meeting, the various modalities were discussed. As to how the eco-based camp could be implemented and managed under the said scheme. In clause 9 of the said meeting, in the said minutes of the said meeting, it was agreed to that in the event that the running of the camp becomes unviable, the Department of Forest, bracket, Wildlife Assam, or the petitioner will be at liberty to terminate this the understanding by serving 3 months prior notice. Thereupon, certain proceedings were initiated against the petitioner. For which an offense report number CH35 was initiated. This offense report was forwarded to the Chief Judicial Magistrate, Tejpur, Punitpur, by the Range Officer, Soridwar Range, Soridwar, dated 3/2/2020. The petitioner, being aggrieved, preferred a writ petition before this court. Which was registered and numbered as WPC number 3745/2021. This court, by then order dated 18/8/2021, after taking into account the various aspects, observed that no coercive measures on the basis of the offense report number CH35 dated 25/1/2020 of Soridwar Revenue Station Range, Soridwar, shall be taken by the respondents therein upon the petitioners along with the members of the petitioner society. This court further finds it relevant to take note of that prior thereto, another writ petition was filed by the petitioner, being WPC number 614/2021, wherein the petitioner challenged. What did he challenge?
My lord, that's Caesar,
The seizure
page 128.
by the divisional forest officer Honitpur by the communication dated 6/1/2021,
16, my lord.
16/1/2021. Both the writ petitions were disposed of by the judgment and order dated 30/3/2023. In disposing of the said writ petitions, this court duly observed at paragraph number 23 of the said judgment that the actions on the part of the forest department also indicates malafide on the part of certain officers of the department. This aspect could be seen from paragraph number 23 of the said judgment, which is reproduced here in under. This court further, taking note of the facts and circumstances, set aside and quash the offense report number CH35 dated 25/1/2020 issued by the Divisional Forest Officer Honitpur and forwarded by the Range Officer Soridwar Forest Range. The interim order was made absolute. Thereupon, a communication was issued on 26/12/2023 by the Divisional Forest Officer, Western Assam Wildlife Division and Field Director Nameri Tiger Reserve, whereby clause 9 of the meeting of the minutes of the meeting dated 26/1995 was invoked. Mr. K. Chaudhary, the learned senior counsel, submits that not only the relevant facts was not taken into consideration, which on the face of it shows malice in law, but there is also nothing mentioned in the said communication that the eco base camp had become unviable for exercising the jurisdiction under section clause 9 of the minutes of the meeting dated 26/201995. He therefore submits on the face of it the communication dated 12/6/2023 is contrary to the minutes of the meeting held on 26/201995. Apart from being also inconsistent with the provisions of law. Mr. A. Borua, the learned counsel appearing on behalf of the Forest Department, submits that he would like to take instructions in that regard. This court, upon duly perusing the materials on record, is of the prima facie opinion that there is no mention in the communication dated 12/6/2023 that a foundation has been laid for the purpose of exercising or invoking the clause 9 of the minutes of the meeting dated 26/1995. Under such circumstances, this court till the next date, so fixed, states and directs that no action be taken pursuant to the communication dated 12/6/2023.
And no restraint will be put on our matter entry into the MI.
No, I said nothing to it.
Develop.
I'm not staying the communication because tomorrow if I dismiss it, if I stay, the period again extends.
Developed.
Daily list item number 2 for admission.
Yes,
My lord, your lordship, my lord, was the opinion. In fact, my lord, it's required to be recited, my lord, as per your.
when did you die?
Yes, my lord.
When did the person die?
Person died, my lord, in the year 1989, my lord.
Oh, then what are you asking for?
That is the ex gratia grant, my lord.
Under,
My lord, that is the to the Martyr family, my lord. The Martyr family, my lord.
under what provision?
In fact, there is some, my lord, scheme, my lord, of the government to, my lord, grant ex gratia grant, my lord, to the NOK of the Martyr, my lord.
Oh,
So Assam agitation, my lord, during this 1989, my lord.
you come under the 89.
Lordship. 83, 84, man. 83, 84.
You are the NOK.
NOK, man.
Who are you?
I am the, my lord, child, my lord, of the second wife, man.
Huh?
Child of the second wife.
Child of the second wife.
Second wife.
Person is Mohammedan.
No, my lord.
Then how is the second wife child has a relevance?
My lord, since it is decided to, my lord, grant to the NOK of the Martyr, my lord.
So,
in
are you a NOK?
that, my lord, because
Have you got the NOK?
in fact, my lord, there is a, my lord, certificate issued by the, my lord, deputy commissioner, my
Show
lord.
me.
That is at page 24, my lord, of my writ petition.
Page?
Page 24, man.
Yes.
This is certificate as per notification so and so and number so and so Assam Public Service Preferential Appointment Rule 1999. In pursuance of Rule 2A of Assam Public Service Preferential Appointment Rule 1999, this is to certify that late Peter so and so, he is the Martyr, my lord, of village so and so PS subdivision Nagaon district Nagaon was killed in connection with his participation in Assam movement on the problem of foreigners, and that Sri Beauty Laskar, this is the petition number 2, my lord, is daughter of the state deceased.
What about the first wife?
First wife, my lord, she has already, my lord, taken away the, my lord, grant, my lord. That was, my lord, in fact, disbursed to her account, my lord.
Oh, this one.
Yes, my lord.
I forgot. You don't have any case.
Yes, ma'am.
Now I remember. Well, this seems to be, I've heard it. Yes.
Lordship.
What case you have?
In fact, my lord,
You have any problem? Go and file a suit because she has already taken. I remember her bank account was closed
lordship,
and that bank account has been now opened
yes, yes,
pursuant to Justice Buzarbura's order.
lordship,
And her specific case is that she has already taken the money.
lordship.
Now, what is there to be direction to whom? Tell me.
In fact, my lord, my prayer is
And that particular document, which on the basis of which you are claiming,
yes,
there the why your mother's name was mentioned, if I remember correctly.
Yes,
Not your name.
yes, yes.
Yes. Now tell me, what is your
In
case?
fact, my lord,
On that day you escaped.
in fact, my lord,
Yeah.
my lord, I worked some, my lord, more data. I got this one rule, my lord, that is, your
But-
lordship is aware that
But Mr. Counsel,
Lord.
she has already taken it.
Lord.
The fight is between you and her.
lordship.
Why should we involve madam or him? Who file a suit?
In
I'll
fact,
say that this you shall be at liberty to file a suit.
lordship.
And the withdrawal of the instant writ petition shall not preclude or bar you for claiming such amount from her.
Lordship.
But this court can't direct now. The 5 lakhs has already been given to her
Yes, yeah.
and she has spent it. So get it
The
from
amount is
somewhere.
already withdrawn.
Selling her house.
In fact, she is the government, retired government servant.
So what? Retired government servant also. But she has money is with her. Now what do you want? This court should direct them to take the money from her and then give it to you. Is it?
In fact, that won't be, my lord, that cannot be, my lord.
So you have to fight with her.
Yeah.
Go and fight in the civil court. But can this court decide whether she has to give or not?
But
You have to wonder, that is a question of recovery of an amount.
my lord, since although she is a illegitimate, is an illegitimate child, my lord. So, in fact, my lord,
Let her take that ground defense in the suit.
Lord.
Why should this court say it?
Yes.
Isn't it?
Yes.
Withdraw.
my lord, in fact, my lord, your lordship give me, my lord, liberty. State of withdrawal, my lord.
Huh?
Your lordship will dispose of, my lord, with a direction to, my lord, approach the, my lord.
I am not giving. I am giving you the liberty to approach.
Liberty.
You may approach, you may not. That is your lookout.
Yes.
Isn't it? If I give a direction tomorrow, you will be bound. Can I?
In fact, my lord,
Isn't it filing of a suit your volition?
Yes.
Then? Okay.
Lordship, I want to submit.
You
one
don't
thing,
submit.
Lordship.
I'm not saying anything against you. Why you want to submit?
No, just,
You want to pay 2,50,000.
no, your Lordship.
You want to pay, then you can submit. Otherwise, don't say anything. You want to pay?
No,
Pay.
Lordship, no.
Pay 1 lakh.
No.
You'll be happy. You want to pay?
No, Lordship.
No, you have got 5 lakhs. Pay 1 lakh.
No, actually, the amount was already credited in the account of Shadhani Loshkar, the respondent number 4. And it was withdrawn in the month of January 2017. Thereafter, the petitioner number 2, here, the daughter of the petitioner number 1 has obtained a certificate, which is the legal year certificate. This certificate is obtained from the Deputy Commissioner's Office, Additional District Magistrate, issued, your Lordship. And here, the martyr's residence known as Nagaon District, Lordship. And on the basis of this certificate, this writ petition has been filed, Lordship. This much.
You want to pay?
No, Lordship.
Then don't say anything. The learned counsel appearing on behalf of the petition submits that taking into account that the money has already been disbursed to the respondent number 4, who had also withdrawn the said amount, he would not like to press the instant writ petition. He, however, submits that the withdrawal of the instant writ petition should not preclude the rights of the petitioner to avail remedy, thereby remedies against the respondent number 4 for claiming a part of the ex gratia so paid to her by the respondent author. Taking into account the said submission, the instant writ petition stands closed on withdrawal. It is made clear that the withdrawal of the instant writ petition shall not preclude or prejudice the rights of the petitioner to claim to claim such amounts from the respondent number 4, if so advised.
Deeply obliged.
Obliged.
Yes. Oh, garbage. What happened?
We have the commissioner file an affidavit tendering an apology.
Huh?
Tendering an apology.
Where is the affidavit?
Lordship.
You filed?
Lordship will file on 21/8. Because with oversight, predecessor has commissioned that particular expert site.
Understood, but the only thing is, you have done that. Now what to do? He, as of now, he doesn't have anything.
No.
But his prospect, how much is the area of land?
10 bigas.
Huh?
10 bigas.
10 bigas is a big area. Leave 1 biga.
No, that particularly is not in use now.
Understood.
My lord,
As of now, but he's,
it will be used, my lord, because of this, my lord, only they are reluctant to now start anything. Because, my lord, that's a commercial space, my lord. My lord, anyway, my lord, I have asked them to, as your lordship asked for on the last occasion, a sketch map sort of thing, my lord, where it is actually exactly located in front of them, my lord. So they will be putting it to me, my lord. My lord, and one more thing, my lord, since lordship, the honorable court's order is there, and can it be still going on, my lord? That is the thing. Other part, that may be
I
inadvertent,
allow it to go on.
my lord.
I allow it to go on.
My lord, that is the matter.
As of now, you are not in difficulty.
My
Are
lord,
you in difficulty as of now?
my lord, thing is this, because of this, my lord, we are reluctant to go ahead with any project, my lord.
The reluctant is
Because,
absolutely a volition on your part.
no, my lord, we cannot.
You tomorrow bill.
We are not in a position, my lord, because suppose we make some residential thing also, my lord, and there we have.
Have you made?
No,
Have
my
you
lord.
sought for permission?
No, we not yet, my lord.
Then
Yeah.
why should we? On presupposition, we will look into it later on. We get your sketch map. Why should I stop it now?
Lord.
Let them carry on for the time being. We'll see on the next day. You get your sketch map. First, who has filed the affidavit?
But the present commissioner, my lord.
Huh?
Present commissioner, my lord, is Mr.
This court.
M.N. Dahal.
Pursuant to the order dated 11/8/2023, an affidavit has been filed by the Commissioner of the Guwahati Municipal Corporation apologizing the commissioning of the, what is that?
Garbage transfer station.
Garbage transfer station in spite of an order passed by this court dated
5/1/18.
5/1/2018. It has been mentioned that the said happened due to a bona fide mistake and due to oversight. It is further seen that the respondent authorities also had submitted that till the disposal, submitted that till the next day, till the disposal of the writ petition, they would temporarily decommission the project. This court have duly heard the matter. As of from a perusal of the matter, writ petition as well as the materials placed, as of now, the land wherein the petitioner, as of now, there has been no construction raised by the petitioner over the land. And it is only at the stage of proposal. So, taking into account the above, this court fixes this matter again on when?
My lord,
Sketch map?
sketch map, my lord. Last week of this month, September. Or my lord.
Fixes the
immediately
matter
before-
again on
immediately-
27th of September 2023. This court duly also accepts the apology as noted in the affidavit filed by the Commissioner GMC with an observation that in future the Commissioner shall not indulge in such, shall take due care of the orders passed by this court. So, taking into account that at present there is no construction so raised, and this court has fixed the matter on 27th of September for further consideration. This court is not of the opinion for the present for temporary suspension of the garbage station till the
Garbage
next
transfer
stage.
station.
It is further observed, the Commissioner, Commissioner GMC is also directed to apprise this court on the next day as to whether there is any other space where the garbage station could be shifted. Mr. T.H. Hazarika submits that he is going to also file a sketch map in the form of an additional affidavit. So he may do so by 25th of September.
Deeply obliged.
Item number 4.
Yes, what is this?
Enhancement of.
Hmm? Oh, same types, same matter.
Yes, similar.
We'll fix it on that day, na? Well, that day on Monday it has come, na?
Yes.
Last Friday it has come.
8. Similar.
8th, na? 8th order is item number.
That is picked on 28 or on 8.
No, I picked, that was picked on
Monday, I think.
Adhikari, the 28th, no, 25th. That was item number,
I'll check. I'll find out.
item number 2,
Yes.
that day.
One.
Yes, yes.
Item number 1.
That number, item number 1, and that has been fixed on 8.
AK order,
Item number.
same order, it will be
Double
fixing
one
it on
P0.
8. Get your computation ready by 8. How much it will be as per the, get the calculation.
Perhaps Lordship will have to make a direction because it.
I am giving that direction. That order, I am not repeating it. It is the same. That is what I am saying.
No,
Get your computation and file your affidavit by 8. And if you fail to do so, this court will pass appropriate orders against the ATC, Kamrup, rural, remember, Kamrup rural, as to will impose compensation upon you to be paid to NHA. Because you see, the order was passed in 2014. They have not challenged that award. So under such circumstances, it was your bounden duty to fix it up. Why haven't you done? Now this amount will be increased as per the award. Now who is going to pay the interest? Tell me.
no, my lord, what we are, I have to be fair to the court. What has happened here, this ADC, competent authority, apparently, my lord, he is not exercising his jurisdiction, my lord, in accordance with the dictum in passed in the arbitration award. Number one. Number two, after passing of this arbitration award, my lord, way back in the year 2014, in the year 2015, he makes a communication, my lord, to the NHI. Now, NHI in turn, my lord, writes to him that on the date of issue of, my lord, that notification under 3A, whatever was done was done. Then he sits about the matter.
No, he
Yes.
can't sit open the matter.
No, my lord,
It is his duty.
Yes.
He has to fix and come up with this and for the award. I have
otherwise,
not challenged it.
otherwise, lordship may direct, my lord, that
I have directed.
no, my lord, since it is an award, my lord, let me complete. Since it is an award, it can be enforced, my lord.
No,
as a decree.
no, it can't be enforced by them now. How do you enforce it now? There was a direction for the recomputing.
Yes.
So recomputation has been done. Who is going to enforce? When the award says that directing the competent authority to hear, are you saying that he has to now file a execution proceedings and then for going for a recomputation? Why can't this court do under 226?
Yes, my lord.
Hey, it was item number 1 or order 2 like you.
That is
28 তারিখ।
25th of this month, item 1,
Same order.
Tasmina Begum.
Lukson?
What communicator could Tasmina Begum.
It is only to compute. What is the problem with these people? Not computing. Compute and finish it up. He wants to get the money, he will definitely now upon the competition, he will go there. And will go for execution.
My lord, that direction was twofold, my lord. One part was directed to the competent authority, of course, he is bound, whom I am representing. Second part was, my lord, the valuation of trees has to be made by the competent department, forest or agricultural department, as the case may be, on the date of taking over of possession. Now, my lord, he has
That
been.
is your
considered-
business.
Yes.
You are the competent authority who has to finalize it. Yes.
They can supplement public petition.
Hmm.
Public petition, public petition.
This petition has been filed by the petitioner seeking a direction upon the concerned respondent to expedite the matter of payment of compensation in terms with the direction specified in the order dated so passed in case number by the commissioner. This court finds it relevant to observe that the order dated where is an award passed by the arbitrator under section 3G of the National Highways Act 1956. The said award, however, has not been challenged by the NHI. The delay in computing by the competent authority in terms with the award would seriously affect and prejudice the NHI, as there would be further interest accrued on the enhanced amount. Under such circumstances, the competent authority with the additional Deputy Commissioner Kamrup Rural is directed to place before this court by way of an affidavit the computation pursuant to the award dated so. List the matter again on so. It is observed that if there is a further delay in computing the compensation, this court shall pass appropriate orders against the competent authority. Ms. S. Burwa, the learner appearing on behalf of the state, inform the competent authority about the order passed today. Now everything remains the same.
What he has done, my lord, he has written, my lord.
I'm
after-
not concerned.
Yes.
File it by way of an.
My lord,
Hey.
my lord.
Yeah, award is same date,
Same that 3%,
same number,
3%.
same number.
No, same.
That is the order which will be passed.
Yes, it is a Girish Kolita, Tahmina Begum, Dharani Sharma.
খালি আরবর পুজোরই ভয়।
Take another matter.
You paid the money?
No, kindly take another matter next week, lordship. In this case, dinner
2
is a
o'clock? 2 o'clock, it is 31,500. This court should do it. Will impose a cost upon 31,500 upon the DC. Who has done it?
In this case, Dinath is appearing also. He has some
So what?
difficulties.
Let the matter be listed on which the learned appearing on behalf of the respondent applies as to whether the amount of 31, which is the remaining amount as per the respondent, has been disbursed to the petitioner.
Next week.
2 o'clock, or the imposition of cost will be 31,500. I'm making it clear. And from that cost, you take that money.
Lordship, last occasion, Mr. Dinath has placed that one statement regarding.
Huh?
On the last occasion, Mr. Dinath has been placed that statement that regarding that disbursement of fund. In that regard, we have filed one additional affidavit that has been not on record. If it's 2 o'clock, then it may be called for.
2 o'clock.
It may be
Well,
called for.
what do you want? You have a further entitlement.
No, Lordship, that affidavit may be brought on the record.
Okay, you go. 31,500. That is the cost. Will direct 32,500 as the cost to be paid within 7 days. 31,000 you pay to your petitioner. 1,000 is for you.
At 2 o'clock, Your
That is the only thing. Somebody has to go there.
May I
My-
please, Your Lordship?
Yes.
Lordship, kindly after some time, Lordship.
Huh?
After some time, Lordship.
Why?
Learned ma'am, learned council.
What is your case?
My lord, on the last occasion,
Huh.
I was directed to produce a record pertaining.
For what?
Uh,
Setting aside should not be issued, quashing and setting aside the acquisition proceeding whereby the land was acquired and made government fast land as to why mandamus should not be issued, directing the respondents to pay compensation or return back the aforesaid land. Now, what has happened?
Lordship,
Which department you are
DC Sonic.
and who is the land?
Land was for construction of Kolia Bhomura Beach.
Fantastic. Have you acquired the land?
Lordship, out of 3 bighas, some kothas, my lord.
2 big,
2 bighas, 17 lechas were.
3 bighas, 3 kathas, 2 lessons.
Yes, my lord.
Yes.
Out of that 2 bighas, 17 lesa has been shown to have been
Acquired.
acquired under LA case number 4 of 7980.
Okay. Then
We are supposed to produce that record along with a.
have you paid the compensation?
I have no instruction, Lordship. I have received the communication today that, my lord, that record could not be tested out till now. They are seeking some more time.
Why? Only thing we require is to whether you have paid the compensation or not.
That land is, as per our earlier affidavit, my lord, still under the occupation position of the petitioner.
You are in position
Yes.
or you have not acquired.
Lordship,
Don't acquire.
only paper acquisition.
Oh, no.
only in regard
We
to
set
paper.
aside the acquisition.
That, your lordship,
That is
because
quite
the
clear.
central government. affidavit
We
says-
set aside the acquisition because the central government do not require. It is in your possession.
Yes, sir. And Lordship, the respondent number 5 already filed of the affidavit in opposition, Lordship. on
One number
24
4.
No,
5,
central, I'm
5 divisional engineer, Rongia division, Northeast Frontier Railway, Lordship.
What does it say?
Lordship says the Lordship, if
The
the
phone number
land
5 affidavit is where? No, there is only we have a response number 4 affidavit.
on 24/8, Thursday they have filed.
Huh?
Thursday they have filed.
It is not common record, my lord.
Yes, what is that affidavit?
E-file, my lord.
What is the affidavit? What does it say, madam?
Lordship, in para 4, they have said if the land of Dag number 210, periodic patta number 53 of village Dulabari number 1 under Bhairapur is claimed by the petitioner to be under his possession. And if it is not under the occupation of the NERIWL, it indicated that the land of Dag number 210 under periodic patta number so Dulabari by railway on behalf of NEC. Therefore, the record of land in question may be corrected in favor of the petitioner after due verification by the revenue authorities. As it is admitted by the petitioner that the possession of the land measuring so is,
You are still in possession?
yes, sir.
Give me that affidavit. So we set aside the cost insofar as that's land. And directing you to remutate it.
Recorrected the revenue record from government funds to the name of the patta. Nowadays under.
No,
mutation-
you see, no. Here possession has not been taken.
No,
neither payment has been made, neither you have deposited in the court. So all these things are there, and by which section 24 hits in, 24B will hit of the new act. And as such, the acquisition has lapsed insofar as their land. I think that is the best way. What do you say, Mr. Barbuzari? What do you say? Isn't that the best way? Because there is one problem. If we go by the 1894 Act, there's a big problem. 1894 Act, once it is acquired, the question of returning does not arise. And if we, what about 48? That Act, 48 of 1894 Act. Now 1894 Act, 48 or
49 speaks of my lord additional acquisition.
no, not additional. No, 1890. This was done under 1894.
1894.
When was it done?
7980. All my lord 7980.
Hey, 1894 Central Act.
Let's may have this.
Hey, that's it. Land acquisition, that's up.
One video.
Second.
My lord may.
Now 48, that is what I'm saying. Yes, I'm right. Except in cases provided for in section 36, the government will be at liberty to withdraw from the acquisition of any land of which possession has not been taken. Wherever the government withdraws from any such acquisition, the collector shall determine the amount of compensation due for the damage suffered by the owner and so on. Now, if we go into this, there's a big problem. Here, the name has already been recorded. So, under such circumstances, although the possession was not taken, on paper, the acquisition has already happened. So, 48 cannot be applied.
Yes.
That is the problem. That was the problem in that Singur.
Yes.
You remember?
Yes.
The Singur problem was that the acquisition was made at that point of time without, there is no provision. That is why the provision is given out here, by which you can return under the new act.
Yes.
But here we can apply 24B and say that it has lapsed.
It has that.
And accordingly, the acquisition insofar as the petitioner's land is bad, cannot be here, for which the land, the mutation records be made in there.
Otherwise, if
That is the only way.
yes, if minor is correct, if 48 is applied, then we have to pay high.
No. The 48 can't be applied.
Yes.
48 will be temporary.
Yes.
48 where acquisition is not completed.
Yes.
And once it is completed, because here the name has already come in.
Yes, correct. Yes.
So
Yes.
under such 48 can't be applied here.
Yes. It has culminated into passing of that award.
Acquisition has already
Yes,
happened.
yes. Now, if 24 is applied, my lord,
That is the only
everything
way.
lapses.
Yeah.
We will be safe. The DC here has, my lord, filed a very short affidavit, my lord, saying, my lord, that.
The instant repetition has been filed by the petitioner, challenging the acquisition of the land of the petitioner in LAC case number 4/1979-80, whereby the land of the petitioner was acquired the brief facts of the instant case is that the father of the petitioner was the owner of a plot of land measuring 3 bighas, 3 katha, 2 lecha under DAG number 210, covered by PP number 53 under Moha Bhairav Pod Moza, village number 1, Dulabari. An acquisition proceedings was initiated under the provisions of the Land Acquisition Act 1894. Which was registered and numbered as LA case number 4/1979-80. Out of the said land of the petitioner, a plot of land measuring how much?
2 bighas, 17 lecha was acquired.
2 bighas, 17 lecha was acquired. And converted, and thereupon the revenue records were corrected. However, though this land was acquired, the possession of the land was not taken. Neither the possession of the land was taken, nor the petitioner or her predecessor in interest was paid compensation. This court further made a specific query upon the learned counsel appearing, learned counsel Mr. B.J. Talukdar, appearing on behalf of the Revenue Department as to whether there is any document to show that any amount of compensation was deposited in the court for acquiring the land of the petitioner. The learned counsel, Mr. B.J. Talukdar, submits that to his instruction, there no amount of compensation was also deposited in the court for onward disbursement to the petitioner. This court further finds it relevant to take note of an affidavit in opposition filed by the railway authorities. Wherein it has been mentioned at paragraph number 4 that it came to the knowledge of the railway authorities that after completion of the work, that the land acquired on behalf of NEC was handed over to NERIWLM, bracket, Northeast Regional Institute of Water and Land Management, Tezpur, Assam. It was mentioned that if the land of DAG number 210 of periodic patta number 53 of village Dholabari number 1 under Bhairav Pod Moza is claimed by the petitioner to be in her possession, and if it is not under the occupation of NERIWL, then the land of DAG number 210 under periodic patta number 53 of village Dholabari by the railway on behalf of NEC be corrected in favor of the petitioner after due verification by the revenue authorities. This court further finds it relevant to take note of an affidavit in opposition filed by the Assistant Commissioner Tejpur wherein at paragraph number 6, it was admitted that the entire land measuring 3 bighas, 3 kathas, 2 lesser was possessed by the petitioner as reflected in the field report submitted by the lot mandal. However, the name of the petitioner was not mutated in respect to the said plot of land. This court, therefore, taking into account the above, this court have also heard the learned counsels for the parties. And also, parties, in respect to the application of section 24 of the right to fair compensation and transparency in land acquisition, Rehabilitation and Resettlement Act 2013. For short, the Act of 2013. Subsection 2 of section 24 of the said Act being relevant is quoted herein below. A perusal of the above section shows that notwithstanding anything contained in subsection 1 of section 24, in case of a land acquisition proceedings initiated under the provisions of the Land Acquisition Act 1894, when award under subsection 11 had been made 5 years or more prior to the commencement of the Act of 2013, but the physical possession of the land had not been taken or the compensation had not been paid, the said proceedings shall be deemed to have lapsed, and the appropriate government, if it so chooses, shall initiate the proceedings of such land acquisition afresh in accordance with the provisions of the Act of 2013. That judgment, Justice Arun Mishra's judgment is what? Indoor development, wherein it says it should be N, not or.
Or not or.
So you have to have both, then only it would lapse.
Yes.
In the instant case, it would be seen that though an award was passed as far back as on when was the award passed?
To that extent, my lord, the materials were silent, my lord. It only says, my lord, my lord comes to the writ petition, my lord, page 13 of the writ petition, 1-3. That is a part of the Jamabandi, my lord. Page 13. Page 13, my lord, right-hand side remarks column, my lord. In compliance with order of SO by number so and so and order ASO dated passed in connection with LA case number 4/7980, land measuring 2 bighas 17 lessons.
In the instant case, the award was award in LA case number 4/1979-80 was passed prior to 1983. Passed around 1983. However, no compensation was paid to the petitioner. However, neither any compensation was paid to the petitioner, nor the possession of the petitioner of the land was taken, as it is the admitted case of the respondent authority. Under such circumstances, this court is of the opinion that the acquisition so made under Land Acquisition Act 1894 in LA case number 4/1979-80, insofar as the land of the petitioner measuring
2 because 17 lesser.
2 bighas 17 lessers contained in DAG number 2110 of periodic patta number 53 in village number 1 Dhulabari under Moja Maha Bhairav Pod in the district of Honipur, Assam, have lapsed. The consequence of the lapse of the acquisition, insofar as the land above said, is that the land reverts back to the petitioner. Accordingly, this court disposes of the incident writ petition with the following observations and directions. Number 1, the land measuring 2 bighas 17 lecher, Zero Katha 17 lechers, covered by DAG number 210, included in periodic patta number 53, located in village so and so, stands reverted back to the petitioner. And the petitioner would be the owner of the said land. Next. This court further directs the revenue officials and more particularly the Deputy Commissioner, Honipur, to make necessary corrections in the record of rights on the basis of the order so passed.
From NF Railway to the Patta. From NF Railway, Lordship. They have already corrected in the name of.
I've already said, na, NF reverted back to you,
Lord.
and you shall be the owner.
Lord.
Shall pass the appropriate necessary order on the basis of the order so passed. Within 4 weeks from the date of passing of the instant, certified copy is served upon the deputy. 4 or 6 weeks.
Can be 4 weeks also.
4 weeks.
It will be only minor paperwork.
7,
What's a bit of before but the contacting council as summons not feeling well. So here the main party is GST Lordship. GST is not, name is not reflected. Here the main party is GST. The name is not reflected in the cost.
Who?
GST.
GST.
GST is the main party. We are the formal party only, Lord.
This is regarding what?
Regarding Lordship, they are
Regarding the deduction of the service tax, my lord, I am appearing for the respondent number 5, Food Corporation of India. So we have not deducted because he has to deposit it. That is our stand in our affidavit in opposition, which we have filed on 24/8/2021.
Taking into account that the counsel for the GST is not present, the matter stands adjourned to
party at the cost of
18th of September 2023. The registry shall show the name of the SCGST in the court list.
Eight,
Wait, please. The petitioner lordship, he has entered into an agreement with the respondent number 6 for by which the respondent number 6 has agreed to sell 12.5 hectares of land to the petitioner. But subsequently, he did not execute a sale deed lot. Then a suit for a specific performance of contract was filed by the petitioner in the court of the civil judge lot, among others. And the respondent number 6 appeared file is WS. An injunction petition was also filed by the petitioner in the suit. That injunction was not granted by the learned track, but the suit is still pending. In the meantime, during the pendency of the suit filed by the petitioner lordship, the respondent number 6 has sold the suit land to the respondent number 7. And thereafter, the respondent number applied for the with mutation, against which objection was raised by the petitioner, but the circle officer mutated the name of the respondent number 7. Thereafter, lordship, the respondent number 7 applied for obtaining a NOC from the Karupetia town committee, and a permission was granted by the Karupetia town committee. And the circle officer lordship, who mutated the name of the respondent number 7 about the suit land, he became the in charge of the Karupetia town committee lordship. And he issued an NOC in the name of the respondent number 7 for the construction of a multi-storied building consisting of basement and G+6 building over a 12.5 acres of land, totally violating the building rules lordship as per the Assam Notified Urban Areas Building Rules 2014 law. And height of the building is 76 feet. As per the rules of 2014, height should not exceed 11.6 feet. I have quoted the provisions of the Notified Areas Building Rules. So, lordship, the complaint was lodged by the petitioner before the Karupetia town committee also regarding the illegal and unauthorized construction undertaken by the respondent number 7. But no action was taken, lordship, even no so-called notice was issued, no inquiry was done, lord, whether the building has been constructed by the respondent number 7 as per the NOC or approved plan. Then, having no alternative, then this state petition has been filed. The respondent number 7 has filed an affidavit in opposition, saying therein that that the respondent number 6 never executed any deed of agreement in favor of the petitioner. In the affidavit of opposition, it is clearly stated. But in the title suit in the WS, the respondent number 6 has admitted that he had entered into an agreement and took the advance of rupees 1 lakh and thereafter 2 lakh from the petitioner law. So this is the case. Now your lordship may be pleased to peruse the I have quoted the lordship may come to page 15. I have quoted the rules, building rules of 2014 lordship. My lord, without disturbing my friend, my lord, your lordship may be pleased to see the prayer portion of the writ application, my lord. These things were not there.
Yes, what is it?
Prayer portion lordship. Page 18.
What was not there, Mr. Kulika? What was not there?
That, my lord, they have challenged now the construction, my lord. That was not there.
Right.
And that's why, my lord,
Prayer
they
A,
earlier, before your lordship, in last order may kindly be seen, my lord.
no, it's okay. Prayer A, what is prayer A? Read it.
NOC has been challenged. Read petition prayer, my lord. It is put up there. Right. Put up there, my lord. Page 18. Page 18, full number prayer.
Prayer A.
A, capital A. Para A. Let him submit, my lord. I will submit.
Yes.
Now, your lordship, please to come to page 15, lordship.
Yes.
Rule 67, regulation for commercial building. The regulation for commercial building shall be as specified. Minimum floor size should be 9 square meter, while minimum width of plot should be 7.5 meters. Where when setback is up to the height of 11.5, minimum front setback 3 meter within 1.5 meter cantilever in upper. Minimum side back, minimum 1 meter has to be maintained in each side, which can be relaxed to only one side if the adjoining plot owner agrees to have a common wall with the building. Minimum rear setback is described, then lordship may come to the lordship page 16, para 40. That the petitioner states that the instant case, the executive officer, Kharupedia Municipal Board, Kharupedia has issued the impugned permission dated so and so illegally and collusively with the respondent number 7 to construct multi-story building over the suit land measuring 12.5 acres covered by pattern number, dark number so and so, so and so. During the pendency of the title suit number 28 of 18, instituted by the petitioner in respect of the said land in Court of Civil Justice, Kamrup District, accordingly, without the title of the respondent number 7 of said land, in violation.
Why
of
are you
suit-
saying that without title of the respondent number?
Yes, lordship, because lordship, when the suit for a specific performance is pending against the respondent number 6 lot. And as per the Apex Court decision, lordship, reported in AIR 2005 XC 104 lots, where the Apex Court held the nature of the property cannot be changed. Transfer of land during pendency of the suit and construction are unsustainable.
Yeah?
Are unsustainable in law.
Show me that judgment.
Yes, Lord.
Show me that. Where is it?
Your
Because
lordship.
as I know,
Yeah.
at best only section 52 will apply. Section
that-
52
that-
will be anything done, you will be subject to the outcome of the suit. That's all.
From this suit, that is correct, lordship, but doctrine of least pendants will apply.
That is what that is the doctrine of lis pendens. 52 is the doctrine of lis pendens. And 52 says there are many. In fact, a very recent judgment also says that whatever happens, you will be subject to outcome. 52
Lordship,
only says that.
when the matter is sub judice.
So what?
lordship, matter is sub judice.
Then let us see the others. So the title is not there. Then, and in violation to rule 3, 4, 12, and 17 of
Yes,
the
lordship,
Assam notified.
they have, lordship, may be pleased to consider that as per the rules, lordship, the height should not exceed more than 11.6 meter. This is a high-rise building has been constructed, lord. For high-rise building, lordship, the rules are different. That is also I have put it, lord. That your lordship may please prepare.
Where is the permission given, sir?
Permission was given, lordship,
Where is the permission?
permission, lordship.
Yes, annexure 11.
Yes, Lord. Page 86. Sorry. Uh, Page 90. Last.
Where is your schedule of your plane?
Schedule.
Schedule of
Schedule
your
of the
plane?
plane, Lordship will find.
Where is your
Just
plane?
on the northern side,
Now, where is the plane?
plane,
Yes, got it.
plane is Lordship, page 27.
Now, if you see the permission has been accorded for a land bearing patta number so and so of Dag number 131936 1937 1938. We are concerned in your suit, it is Dag number 13, huh? Only, yes, that is what. 1938. So that is only 12.5 letters. How much other lands are there? How much lands are there total?
Totally the area of the basement is, these are given, my lord. Other, actually, the respondent number 7 parcels from the other brothers. also.
Understood. How much land is there?
Land is.
Land is only 12.5.
No, it can't be. Because
One-
12.5 letters is only in Dag number 1938.
No, Lordship, may please to peruse the last NOC.
All three.
Area of the basement 638 square meter, Lordship.
Huh?
Area of basement.
Mr. Roy, kindly see that permission has been accorded in what land? A plot bearing patta number 1144, 1145, 1146 of Dag number 1936, 1937 and 1938.
Yes.
Your suit is for 1938. That is of 12.5 letters.
1938 is there.
Huh?
So,
Oh.
38 there.
So, what about the other two lands? How much is the land? A 1936 and 1937?
But my submission in this, Lordship, the area shown in the
Mr.
NOC.
Quilter, on that day, I was about to dismiss it. He took time on the ground that you are not present. So therefore, I am keeping you here only for the purpose of that. Otherwise, I don't require. Yes.
Lordship area, if there are other ducts, Lordship, then the area of the built up area would have increased. Lordship, see for how much square meter the permission has been given.
How much is the other lands?
For other land, permission does not show, Lordship.
What? It is very clearly given at page 90. There are 3 ducts. 1936, 1937, 1938.
Then, Lordship, see the square meter 638.
So,
638.
so what is wrong with that? How much lands are there in 1936 and 1937?
The respondent, Lordship, has not disclosed in his.
Not necessary. It is you who is alleging violation. You have to say that there is no lands in 1936 and 1937. Are you saying that?
I may be allowed to file an edition.
No, nothing. This goes for today. I give you 2 things. Either you withdraw and file, you want to file injunction, goes, or this court today decides and finishes it off. Or he would obviously like the second option.
Pardon, my lord?
Mr. Quilter will obviously like the second option, where this court finally takes up and dismisses your petition. But I can give you an opportunity, go and file a suit out there and get whatever injunction. If you want, you can go and get an injunction. That is your lookout. But otherwise, this court is otherwise going to dismiss. What do you want?
Injunction petition was filed, Lord.
Understood, not for this. You filed an injunction not to transfer.
Lordship, against the.
That injunction was refused.
Against the municipal board or the corporation, Lordship, without giving notice. Declaratory suit cannot be filed. Only suit for injunction case.
Then why are you not filing it? You can file it.
Liberty may be given.
Why should I give a liberty? You are always there. What do you want? Withdraw? I can only say that withdrawing of this writ petition shall not preclude your right to
File.
take appropriate steps as permissible under law.
That it can be disposed of.
Dismissed,
Disposed of.
disposed how? Withdraw.
By observing that the disposal of the writ petition will not.
So
be-
you withdraw with a liberty.
I am withdrawing.
Yeah. Right. Mr. SP Roy, the learned counsel appearing on behalf of the petitioner submits that taking into account that there is a suit pending, being title suit number 28/2018, whereby the petitioner have sought specific performance of the agreement dated
Agreement 1911.
19/11/2015. And the effect and if constructions are carried out on the said land, may affect the petitioners. He would not like to press the instant writ petition and instead may take such appropriate steps in the said suit or by way of separate proceedings as envisaged under law. He submits that the withdrawal of the instant writ petition should not affect or prejudice the petitioner to raise all such contentions as made in the writ petition. Taking into account the above, the instant writ petition stands closed on withdrawal. The petitioner would be at liberty to take such steps as permissible under law in the pending suit or by way of a separate proceedings.
Right.
Daily list item 9.
Mr. Hulda, that day I was about to pass. Then he
Actually,
said it won't be.
Her name was shown, my lord, she missed it.
Huh?
On the last occasion, my lord, she missed that the case
Ah.
was dismissed.
It was about to be passed. So his argument was only to sustain it till today was Mr. Quilter was not. Yes, Mr. H. Puragai. Tell me, what is it? Oh, this is a very important matter. Affidavit filed? I've asked you to file an affidavit,
Yes, yes, we have written to the department, but no
but the
instruction.
department is not bothered.
No, the department is yet to send us any. Kindly grant us some time so that,
No, this is a very serious issue.
minor. We have written a detail or letter to them, asking them.
That can a nephew would be entitled to the benefit?
Yes.
Would be a NO
Whether he will be an.
for the purpose of this.
Yes.
No, there will be no end of the matter. The nephew's right is how? He's class 2. He's a class 2.
Class 2.
Or if it is, this is a Mohammedan. If it's a Mohammedan, then in that regard, what is his right? Can he be also entitled to? This is a very serious thing.
Yes.
Unless the government wants to pay the money just for the sake of it. Because the intention must have been only to protect those who are affected on the basis of a market.
Yes.
Isn't it?
Yes.
This court, by an order dated 4/8/2023, had granted time till today to the Revenue Department to file an affidavit explaining, clarifying as to whether a nephew of an unmarried martyr can be considered as the next of kin for grant of ex gratia of an amount of rupees 5 lakhs in terms with the scheme dated 10/12/2016. The revenue authorities, however, have chosen not to file an affidavit. The council appear representing the revenue authorities, Mr. A. Bhattacharya, however, seeks for an accommodation. This court fixes this matter again on 29/2023. It is made clear that if no affidavit is filed, this court shall presume that the respondent authority revenue department has no objection to the granting of the benefits even to the nephew of a martyr.
Much okay. Item number 10.
Hmm.
Lordship, matter is pertains to non-payment executive amount, my lord.
Aggression of what?
I notification, my lord, 1511, my lord, 14.
Huh?
Accident. Accident.
When did you die?
5/4/2018, my lord.
The entitled to accident?
There's an accident, Lord. We have filed affidavit, Lord.
Accident where?
Yes, Lord.
On the road?
Road.
Dispose.
Sorry.
It exists, yeah, good.
Matter of your taking removal of an overground water pipe laid down by Zyka. At the Bureau area.
Oh, affidavit not filed. Matter pertains to what?
Lordship, removal of an overground water pipe laid down by Zyka in front of the petitioner's land.
To remove the overground water pipes existing in Duro Tiniali Junction in front of the petitioner's land in southern side of the junction. Oh, where's your land?
Lordship, right next to the footpath. Lordship can see the photograph at page number 9.
Page number
9.
19.
Yes.
Oh, this one.
Yes, Lord.
Mhm. And this is not used.
No.
It's not using. They are not using this pipe.
Till now, there was no water supply.
Sure.
Yes, Lordship. Maybe as of now, maybe they have started supplying water, but when we had filed the petition, there was no water supply.
Then it lies where?
It lies in front, right in front of the petitioner's land. Lordship. Lordship can see at page number 9.
Petitioner's land or petitioner's house. Your ingress and egress is disturbed.
Yes, Lord.
Huh?
Yes.
How?
Lordship can see the pipeline.
Yeah, the
there,
pipe
right in
is
front of-
there, but where is it?
There on the right hand side is my plot of land.
No, there is a footpath out there.
Yes, Lordship. That footpath is also
Footpath,
very,
and beyond the footpath, there is some what you call the drain out there. Where the pipe there. How are you affected?
Lordship, my gate is right in front of that.
Huh?
The entrance is right in front of this pipeline, Lordship.
No, it is not so.
Yes,
How is it?
Lordship. Even if I have to
There is some wooden thing. Ah, yeah. Yes, you are not using it. Who is paying for the jal board?
As Bora appeared.
Oh, they are not paying. We ask them to break it.
In fact, this location, I keep on saying this location is very near to the Tiniali point. Zuro Tiniali is on the, if we go from this side, it is on the,
I know it.
yeah,
It is not for me.
yes.
But I am asking you, this pipeline, don't you think it is required to be removed?
It seems so.
Huh? You are making such beautiful bridges out there, and now you are having this pipeline out there. And where is Mr. S. Bora? No affidavit file, nothing has been done.
Let me inform.
Inform me. We'll take it up the matter after some time. We'll take it up at 2.
Item number 13.
Listener is in possession of a particular plot of land measuring 1/5 acre and
And my lord, in the year 2014, my lord, on 18th of August 2014, 2 rooms of the petitioner were demolished by the authorities, by the other deputy commissioner, my lord, Kamrup. Immediately thereafter, petitioner approached this court and filed a writ petition, my lord. That writ petition is WPC number 4033 of 2014. And initially an interim order was passed not to disturb with the possession. And immediately after the interim order, in order to circumvent with the order passed by this honorable court as well as the writ petition, my lord, another notice was issued under 18.2 of this rules, my lord, by the circle officer. Otherwise, circle officer is also not having any authority to proceed under 18.2, my lord.
Is it so?
So it is a deputy commissioner, my lord.
Show me. See, rule 3, rule 3, I know it.
May I read, my lord?
Yes, please.
My lord, ejectment. Subject as herein above provided, the deputy commissioner may eject any person from the land over which no person has acquired the right of a proprietor, landlord.
No, not on that. I'm saying rule 3.
No, my lord, it was the direction was
Understood. You kindly see rule 3.
rule 3 of this rules, my lord.
Ah,
Delegation of power, my lord,
yes.
by deputy commissioner.
Read it.
The deputy commissioner may, by general or special order, delegate any revenue officer within the district or all of the powers conferred by this rule, including the power to receive applications for land, provided that no officer
Number
towards
two.
the rank of
Number
a
two.
deputy collector shall pass orders to issue
Mr. Council, number 2.
Delegation of power under Rule 18.1 and 18.2 may be made only by a sub-divisional officer or to a circle officer or circle officer attached. But that is not the issue, my lord. Subsequently, my lord, the petitioner also filed a miscase, my lord, in 2014 itself. And it was stayed. Subsequently, my lord, both the writ petitions were heard together. Writ petition and the miscase were heard together, and it was disposed of by order, my lord. Lordship will find it page 43.
Miscase.
My lord.
Miscase 18/2/2019.
Yes, my lord. 18 to 2009. Both the miscase and the writ petition was disposed of, my lord.
Ah.
My lord, operating court, Lordship will find that paragraph 6 and 7, my lord. Be that as it may, the eviction process has to be prepared by a notice under Rule 18.3 of the Settlement Rule, made under Assam Land Revenue Regulation 1986, and in absence of the same, an eviction process will not be legally sustainable. In view of the above, the writ petition is disposed of by directing that the petitioner in question shall not be evicted from the land under his position without following the due process of law, without issuing notice under Rule 18.3 of the Settlement Rules as indicated above. Against this order, my lord, neither state filed any appeal, my lord. Subsequently, my lord, Lordship will turn to page 46. This notice was issued again by the circle officer. Although it is not mentioned whether that it is a notice under 18.3, they only call for the produce certain documents before the deputy circle officer, my lord. Accordingly, the petitioner approached this court by filing this petition.
Then?
And a stay order has been passed by lord. And in the meantime, they have filed an affidavit also. They think that the process initiated are not under 18.3. That affidavit they have stated. If that is so, my lord, that petition may be disposed of by stating that my apprehension was that it was a notice to be made under 18.3, but it was not specifically mentioned.
What is the difference with 18.2 and 18.3?
Under 18.2, without any notice, they could have proceeded with the eviction, my lord. Under 18.3, the procedure prescribed is there that has to be followed, my lord.
So this is 18.3?
This is not 18.3 in the sense, my lord. They have also stated this is not a notice under to be 18.3, but in affidavit.
Here you are given an opportunity.
And accordingly, my lord, we have also approached the circle officer because while
Who is the revenue? Who is paying here?
Our name is not shown.
Not necessary. These type of matters, Mr. Bachchaji, you are right. Every day you are looking into, both of you are looking into these revenue matters. Do you require any names to be shown out here?
No, actually we could not bring the file because our name.
Extra file to do. that. Why do you need all these things? This court has directed you to take step under 18.3.
Yes.
You have issued a notice asking him to show the papers.
Yes.
Against that, he has come. And the court has passed an interim order. Now, the fact that whether it is to be 18.2 or 18.3, although this court has said 18.3, but 18.2 is also permissible. There's no
Okay.
quarrel that 18.2 is not permissible. Can you say that 18.2 is not permissible?
Otherwise, my lord, the specific order is there. The state also have. it might
Understood,
fix
the
one, right?
order is there, but can you say that 18.2 is not permissible in your case?
I have paid Toji, my lord.
So, Toji is what?
Yes, my lord, that is there, that is there.
You
But since the order is there,
have been only asked to appear before the undersigned at so and so with all relevant papers.
then I
Then,
have already appeared, my lord, because
then what happened?
there was an interim order that it is pending like that.
So very well, they won't take action, that is their lookout.
There is an affidavit. There is an affidavit filed by the respondent number 4, which clearly states in page 4, my lord, the petitioner is an unauthorized occupation of government land earmarked for public purpose.
Hmm?
So it is covered under 18.2, page 4, paragraph 6.
Then why did you issue notice asking him to appear and show documents?
Because previously he has approached the High Court and the court has asked us to issue notice. So accordingly, an opportunity has been
Court
granted.
has given you and directed you to take steps under 18.3, isn't it? Read
Yes.
what did Justice Medhi pass? Or we will assume that 18.2 also you allow people to be heard. You want that? Very well.
No,
No, you want that?
No.
That is what you have done. You say that that notice is a notice under 18.2. If that is the stand of the government, then we take it. It is on affidavit.
it was with regard to due process of.
Then
He was given this notice and he was asked to appear before the circle officer for a hearing on 13th of June 2021.
what happened thereafter?
Thereafter,
My instruction is that, my lord, I have appeared. Pursuant to an interim order, there was a direction to appear. And I also appeared, my lord.
Then
Then, my lord, thereafter matter is pending like that.
he is in possession of a government and there is no doubt about it. He has
so
not denied
should
it.
we
He has paid
continue
to-
the interim order?
No.
And adjourn the matter sine die?
No.
No, let us do it. In spite of the court's order, there is a direction for him to appear. He has appeared and there is no instructions from you and you have filed an affidavit on 8th of September 2021. Unless the circle officer is hand in glove with the petitioner.
There's
You
no-
see,
There's no such thing. In fact,
there has to be something. On one hand, right, left and center, you say that 18.2 there is no notice, you can throw anybody up.
if it is earmarked for a public.
This court directs you to take steps under 18.3. You have not challenged that. See, that is it. 18.3 also, what is the mandate? That you ask him, give him 15 days, look here, 15
Notice
days
time.
I am giving you to vacate the land. You don't do it. You say, asking him, kindly appear and show us. What is it? Very interesting is, he comes before this court and says that don't evict me. This court obviously passes an order not to evict. Directing him to appear before the authority. He appears before the authority. And you are silent. And you file an affidavit also to that extent, then now you say that this is 18.2. So what is it? Either the petitioner, either the circle officer concerned, when he goes on one way, on the other highway, the Assam Land and Revenue Regulation and the settlement rules moves. Either that must be the reason, and he does not recognize the law. or there has to be a hand in glove with the petition? Which one? You have to tell me.
It-
You are trying to
because
defend the say.
This notice doesn't specify whether it is under 18203.
He says on affidavit that it is 18.2. See? Doesn't he say so? Which you have also reiterated, saying his affidavit.
Let me come up specific as regard why this notice was felt necessary, because normally
What do you want to do?
this is not an 18.2
I
notification.
hope you don't also want this court to be in the same status of the circle officer who does not know the law.
Yeah.
Or you don't want
I'm-
this
I'm-
court also
I'm
to
not-
be have any hand in the petitioner.
No, definitely the court will decide, but
Then
ultimately
there
my
to
affidavit
execute?
subject matter.
The simple thing is there was a notice given to you. The look here, you kindly show us documents. That's all. He has appeared. Why haven't you taken any action? On one hand, you say that these people needs to be thrown out from government lands. You have submitted application for settlement.
Yes, my lord.
Settlement is pending.
Yes, my lord. That is has been annexed, my lord.
When?
There is petition. In 2000, my lord, 14 itself. My lord. Lord, people kindly come to page 22.
Then page
Page 22, my lord.
20. What is your instruction as regards the settlement application?
That application, we don't have instruction. In fact, with ad regard, that application will just dispose it of within a time frame limit. So let it be disposed of. Page 22.
Within a time frame. The deputy commissioner may be directed to dispose of his application.
Until then, nothing to be done.
Easy and circular.
And tell me, how are you going to go with this application? Means you have a particular mode by which of filing an application. Tomorrow, if you reject his application on technical grounds that it has not been uploaded in the internet or what you call your site, what do you do? And you can't decide then.
Lords may observe.
The what?
People be kind enough, my lord, to dispose of this application, directing the petitioner to appear before the deputy commissioner in a specified time. Deputy commissioner on board, my lord, will take all materials from report, my lord, he will dispose of that, my lord, if it's on notice, as well as my lord, his settlement application. So thereafter, he further agrees, my lord, it will be disposed of it. Otherwise, my lord, this will till then, my lord, till it is not a lordship will take the outer limit of my lord 4 weeks, my lord, within that deputy commissioner will do. Lordship will direct
Mr. Counsel,
deputy
where is the receipt of this application? How do I know that this application was filed?
My lord, that statement is there, my lord.
So what?
I'll file a fresh, my lord.
Fresh means, you see, there are two course of action. Either this application needs to be disposed of if it has been filed in 2014.
Yes.
But where is it?
That endorsement is not there, my lord.
Because you see, when was the earlier
Next,
petition?
earlier petition also.
Earlier petition, when was it filed?
It was in, my lord, what happened, my lord, on 11th of August, 2 rooms were demolished without notice. Thereafter, immediately thereafter, the restitution was filed. On 28th of August, interim order was passed.
But there is not a single mention in your earlier application about this application.
Because, my lord, it happened simultaneously, my lord, probably.
What?
Because it was first demolished, my lord, in the,
You say that you have been residing out there for 32 years
Yes.
and you have not submitted an application because this is also dated 1/8/2014. Whereas the writ petition was filed simultaneously at around that time. Why haven't you mentioned? Because here, this application, this court has the difficulty to say because there is no receipt. On top of it, you have a stamp. The stamp is also not cut. How do you say that whether this application at all was filed or not?
that's what is.
Hmm?
What if we direct to file a fresh application? General file a fresh. Within a time frame.
Then the question becomes different, na? If I allow you to file a separate application now, meaning thereby this application has been filed now. After the passage of all these things have happened. Level. The instant writ petition has been filed by the petitioner, challenging the notice dated 21/6/2021 and for a direction upon the respondent authorities not to evict the petitioner. A perusal of the writ petition shows from a perusal of the writ petition, it is the petitioner claims that he has been residing upon a plot of government land since 1982 by constructing a permanent structure. The said plot of land measures 1 katha, 5 letters covered by Tozi number 388, dag number 305, village Numoli Zalo in Moza Tinduri Bhupa in the district of Kamrup Rural. The petitioner also claims that he had submitted a representation on 1/8/2014 before the respondent number 5, that is the sub-deputy collector, Amingaon Revenue Circle, Amingaon. Pursuant to an action taken by the respondent number 7, whereby pursuant to an action taken by the respondent number 7. It is the further case of the petitioner that pursuant to the said representation, it is the further case of the petitioner that no action was taken on the said representation. And on the contrary, on 11/8/2019, a notice was issued by the respondent number 6 and 7. And on the other hand, on 11/8/2019, the respondent number 6 and 7,
2014.
6, 7, and 8 visited the property of the petitioner and demolished a part of the residential building. It is under such circumstances that the petitioner filed a writ petition being WPC number 4033/2014 before this court. In the said writ petition, there was a interim direction so passed that the petitioner should not be evicted from his property without following the due procedure. However, subsequent thereto, the said writ petition was disposed of by an order dated 18/2/2019, thereby directing the respondent authorities that the petitioner should not be evicted from the land under his possession without following the due process of law and without issuing notice under Rule 18(3) of the settlement rules. Subsequent thereto, on 21/6/2021, a notice was issued by the Circle Officer, North Guwahati Revenue Circle, wherein it has been mentioned that the petitioner will have encroached upon the land covered by Dag number 305 of village Numoligol under Moza Chinduri Gopa under North Guwahati Revenue Circle. And the petitioner was directed to appear before the Circle Officer on 30/6/2021 at 10:30 a.m. along with all relevant documents. The petitioner thereupon, apprehending that he may be evicted, had filed the instant writ petition. It appears from the records that this court, by an order dated 29/6/2021, issued notice and further observed that the petitioner should appear before the Circle Officer on 30/6/2021, but the possession of the petitioner should not be disturbed without the leave of the court. Thereupon, the matter has been pending and the interim order passed earlier continues from time to time. It reveals from the record that an affidavit in opposition was filed by the respondent number 4. That is the Deputy Commissioner, Kamrup Amingam. This affidavit was filed on 6/9/2021. It was mentioned that the said notice dated 21/6/2021 was issued by the Circle Officer, North Revenue Circle, only for the purpose of getting information under what capacity the petitioner have been illegally residing over the plot of government land. It was also mentioned that by issuing the notice to the petitioner dated 21/6/2021, the Office of the Deputy Commissioner, Kamrup Rural, was not initiating steps for evicting the petitioner from his property as alleged. It was further stated that the petitioner is in unauthorized occupation of government land earmarked for public purpose, which is covered by Rule 18.2 of the Settlement Rules framed under the Assam Land and Revenue Regulation 1886. Under such circumstances, the respondent authorities had the authority to exercise the power under Rule 18.2 in the instant case. It was further mentioned that keeping in view the order passed by this court in WPC number 4033/2014, the notice dated 21/6/2021 was issued only for the purpose of conducting a hearing on unauthorized occupation of the petitioner on the government land, and it was not intended to be a notice of eviction by any stretch. It was further mentioned that the said government land, wherein the petitioner is in occupation, along with the other plots of land, along with the conjoining lands, was initially reserved for the Kamrup DC Court establishment. But later on, these plots of land was allotted in the name of Biotech Park, a Government of India sponsored scheme. There is also a denial in the affidavit in opposition that the petitioner had or his predecessor in interest had constructed any houses over the said land in the year 1982. From the above pleadings, and upon hearing the learned counsels for the parties, it transpires that the notice dated 21/6/2021, on the basis of which have been impugned in the instant proceedings, and on the basis of which the apprehension had been created in the mind of the petitioner that he would be evicted, was only a notice issued for the purpose of getting information as to under what capacity the petitioner was occupying the government land. This aspect of the matter is very clear from a perusal of the affidavit in opposition filed by the Deputy Commissioner Kamrup Rural. Under such circumstances, it is the opinion of this court that no interference is called for to the writ proceeding, to the impugned notice dated 21/6/2021. Be that as it may, this court further finds it relevant to observe before concluding that the respondent authorities shall be at liberty to take such steps as permissible under law, and also by taking into account the order dated 18/2/2019 passed in WPC number 4033/2014 with the above the instant petitions.
Obliged. But if regarding the application,
That is not an application. That is not an application. You are saying it to be an application, no, for allotment. That is an application. You are complaining that the respondent number 7 had barged into your house.
there's a prayer for it. There is also
Not
prayer.
fair, all these things. This I'm not going to consider. You file your application, you whatever you feel like, but that can't be constituted to be an application.
Obliged.
15.
This is creating accuracy. The husband of the petitioner died in a motor accident.
1 lakh,
2 lakh.
1 lakh.
My lord died on 12/2021.
22.
21, my lord.
When did you die?
Died 12 January 2021.
Show me.
My lord, fire at place 16, my lord.
12 January 2021. When did you file your application?
Application file, my lord, place 20, my lord. 17/6/21.
And 2 months you filed immediately the requisition. Not even 2 months, 1.5 months.
My lord, and
Huh? Any instruction?
Instructions, my lord, awaited, my lord, here. Lord, the death certificate itself is also not annexed to the, my lord.
No, let him, you verify and make payment if it is
Lordship is disposing of,
disposed.
yes.
my lord, item 21 also similar, my lord.
21, my lord, perhaps, my lord, my colleague has received some instruction.
খালি ইয়াত এটা লিখি দিব দেই. It made clear that shall verify, shall submit the certified copy of the instant order, comma, a certificate of NOK, next of kin certificate, as well as the death certificate of the deceased.
My lord, in this regard, I want to submit one thing, my lord, the NOK certificate is not recorded in granting accuracy, my lord. Because there is a notification, my lord, which documents are required, my lord, that is prescribed by the.
Who are you? In that case,
My lord,
who are you?
my lord, I am the.
You are the wife. So in the death certificate, the name is there.
Yes. That certificate is required, my lord. In second place, my lord. What is the documents are required, my lord? Here prescribed, my lord.
Hmm? Where?
My lord, in second place, my lord.
Huh?
Second place.
What are the financial
Yeah,
paid? Yes. What are the documents required
Yeah.
to accord sanction? Report of the superintendent of police postmortem report of the death certificate.
Death certificate, yes, my
So
lord.
what about the report of the superintendent of police?
That will be submitted by the, yes, my lord.
What about the postmortem report?
And postmortem.
You will have it
No,
100%.
He will be having it.
Then
That will be submitted, my lord. Postmortem.
postmortem report
Yes.
and report of the circle officer No.
That also
along with the
submitted,
death certificate. What is this, etc.?
et cetera, my lord.
NOK?
NOK
NOK is
not
otherwise required, my lord.
required, my lord.
Huh?
NOK is required.
Because this is given to NOK.
That is
Then
the basis.
Without the NOK, how are you?
That is the basis,
My
my
lord,
lord.
Unless you show something that you are the wife
yes, my lord. I will show the.
or
other
such
documents,
document
but
which
the-
would show the NOK, the next of kin certificate issued by the concerned deputy commissioner,
Yes,
deputy commissioner, na?
my lord.
Deputy commissioner of the district, or such certificate which would show that the petitioner is the wife. In the death certificate, it will be mentioned, na?
Yes, my lord, and
The
voter
death
ID, et
certificate-
cetera.
No, voter ID, no. The death certificate, it will be mentioned.
No, my lord, difficulty arises, my lord. She is the wife. We do not know if there are other children. So later on, my lord, apportionment problem comes. We have faced it, my lord. Therefore,
Next of
Yeah.
NOK,
Yeah.
give it NOK. Because here it is given to the NOK and the word is etc.
My lord,
Etc. is there.
et cetera is there, my
So NOK is etc.
lord.
my lord, he will,
21 also same.
my lord, he will lay the claim, my lord, before the deputy commissioner. Lordship. Then in turn, DC will, my lord, send a proposal.
No, this will be a claim before the commissioner and secretary.
No, my lord, commissioner and secretary, my lord, because deputy commissioner at the first
No,
instance.
he has
my lord,
already filed it before the deputy commissioner.
Yes.
It will be taken from there. All my orders are to the deputy commissioner. Deputy commissioner is only given when the commissioner and secretary has already sanctioned.
And another
It
notice,
is only in that circumstances I've given.
my lord, in this section,
See, there are many things. With him, so many litigations are there because of this. Victims compensation, this compensation, that compensation. Once I got 5 matters of him, and everywhere that
Yes,
it
yes,
is
yes,
different.
yes, I got it.
So
Yes.
when, just for example, in the victims compensation, the person concerned in what it is one of your matters, na?
Yeah.
Where Sahar Ali and Bahar Ali was there. There was a direction being given. Yes, it is your matter only, M.H. Hussain.
back with
Yes. So their wife, what has happened? The son, the elder son of Bahar Ali and the wife of Sahar Ali.
Yeah.
Both of them filed a writ petition. Now the person had died, both the persons were killed. So victims compensation is there.
Well,
Now the judgment specifically says, or there is a direction to the DLSA that you have to pay compensation under 357 to the wives
why?
of Sahar Ali and Bahar.
Well,
Now here, what he does, he files one by the son of Bahar Ali, who is 46 years old,
well,
and the wife. Wife of Sahar Ali is okay.
okay.
But what about the Bahar Ali?
Hmm.
Can't be.
And
So then again, you can't pass similar orders. So these needs to be looked into.
yes, so therefore, my lord, I have submitted because later on, my lord, these apportionment problems comes.
No,
in.
no, the NOK is required.
Yes, my lord.
NOK. Same.
Lordship may also kindly direct, my lord, once he lays a claim before the commissioner, my lord, the commissioner will, my lord, call for a report. My lord, that will give us a handle, my lord.
No, I've directed the commissioner will dispose of the matter within so and so. I'm asking him to submit only to the commissioner,
My
the certified copy, and thereupon the commissioner will do the needful.
in this regard, my lord, the notification 6th of December 2014, my lord. In respect of ex gratia matter, my lord, all the powers delegated to the deputy commissioner, my lord. I have given that notification also there,
Hmm.
my lord. 6th of December 2014, my lord. Power is delegated to the deputy commissioner.
Hmm.
Yeah. Take it, my lord.
14th of December.
Now then I will do one thing. I will direct it to the deputy commissioner
Yes,
and with a further copy to be given to the commissioner.
yes, my lord. That-
Yes, because these are the only two authorities,
Yes,
because
sir.
my lord, the.
No, the problem arises is the deputy commissioner's thing is I have sanctioned it, but the revenue is not paying. That is why I direct the revenue. Now the revenue one it is given because this deputy commissioner is under the revenue.
Yeah, so, yes, so therefore lordship will rope in, my lord, both the authorities. Both the deputy commissioner, they cannot escape then, my lord. Because they will be duty bound, my lord, to comply with court's direction. He will lay the claim before the deputy commissioner, once the.
Now,
deputy
his
commissioner-
claim is already laid.
My lord, no, his claim is laid, my lord, but that is
So
not.
if I
that is not
direct the
sufficient.
commissioner can call from the deputy
Yes,
commissioner.
yes,
That is the
yes,
thing.
yes, that is.
Why
also
I have
possible.
done it because what I have seen again, the problem is if I only direct the deputy commissioner comes up and says, look here, I have done my bit,
Yes,
but the money is not being sanctioned by the revenue.
that can also be done.
So therefore, if you instruct the the revenue,
Yes.
then he will direct see to it that the deputy commissioner does it.
No, no, in fact, my lord, the authorities are doing it. My lord, there are orders passed by my lord, which are, my lord, now put to contempt. In contempt, my lord, when we are receiving the instruction, the first instruction we received that the moment, my lord, the claim is laid before the commissioner, my lord, he. my lord,
He will
communicates
do
to
the needful.
yes,
So
no,
I
he
don't
will-
need to change all these
Yes,
things, but
yes.
these are the documents which I have to give.
My lord, the time limit lordship has fixed 2 months, my lord.
3 months now.
Yes, yes. My
Now
lord,
it has become 3 months.
Yes, yes, I'm obliged. I'm obliged.
21 days.
My lord, 21, my lord,
Yes, what is it?
my lord, that amount has been sanctioned. We have-
Sanction.
Yes,
Now their problem arises. Therefore, here the direction has to go to the DC. See, the amount has been sanctioned by you.
no, amount has been sanctioned, my lord.
by the deputy.
You see, on perusal, here, so the sanction is accorded for payment of an amount of rupees 2 lakhs, not or exceedent to Asma Khatun Bibi. You are
Oh, this
No,
Quintal
next page. Third page.
Asma
Rina.
is not- not-
Rina Bosumotari.
Rina Bos-
Yeah, Rina Bosumotari is the petitioner here, my lord.
So here, this is it to any the amount is to any whole opportunity. Mr. Arbor Pujari, Mr. S. Borua appearing on behalf of the Deputy Commissioner Kokrajhar submits that the amount of rupees 2 lakhs have already been sanctioned in favor of the petitioner on the basis by an order dated 15/11/2021. The learned counsel for the petitioner as well as the learned counsel for the respondent submits that they have no instruction as to whether thereupon the payment has been disbursed to the petitioner. Be that as it may, this court directs the Deputy Commissioner Kokrajhar to disburse the said amount of rupees 2 lakhs to the petitioner within 15 days from the date of service of a certified copy of the instant order along with the bank details so submitted.
Yes, my lord, lordship will direct the petitioner, my lord, to appear before the deputy commissioner within a time-bound period, my lord.
Till 15 days.
15 days, my lord, he will also have to appear, he will have to, my lord, furnish the bank account details.
That is what
Yeah.
that is what I am directing the certified copy along with the bank details.
Yes, 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 my lord, my lord.
He will submit it.
Yes,
Then
yes.
only the payment,
Yes,
the
yes,
15
yes,
days
yes.
will start.
Yes, 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 my lord.
With the above so and so. That said communication is kept on record. The order dated 15th of November 2011 is kept on record and marked with the letter X. This is done for this, 2 year 21. What is the other one?
I am obliged, my.
15. Another thing for one Asma Khatun Bibi. Who is it? Any of yours?
That matter is not listed, my lord, perhaps, my lord.
It is also execution.
No, it is actually say, my lord, perhaps, my lord, they have chosen not to approach this honorable court.
Okay.
There are instances, my lord, where, my lord, without approaching this honorable court, my lord, they get the amount.
These type of litigation, these type of notifications are helping Mr. M.H. Hussain.
My lord, we are also taking up the matter with the department, but my lord, welfare state, my lord.
Timing item 5.
My lord, in this case, my lord, I have filed because the last occasion.
Wait,
No, no,
what is this additional affidavit?
no, my lord, they says that, my lord, they have paid in last occasion, they have, and they have shown one statement before this honorable court by Mr. Nath. So against this statement, my lord, I filed this affidavit. In this writ petition, my lord, we are claiming only 12 cases, my lord, these are unpaid. So against this, only as per direction of this honorable court, 50,000 has been paid. They showing that, my lord, which are bill earlier paid to, my lord, which are not disputed, which are, my lord, they have already paid. That, my lord, try to project this, those payment along with this, my lord. In respect of this 12 bill, how much they have paid, my lord, they have not stated. Because in writ petition only involved in 12 cases, my lord.
What is this annexure 1?
That is the statement they have shown before this honorable court last occasion, my lord. So that is, my lord, your lordship kindly see that 12 cases, they have mentioned 12 cases. But these 12 cases, my lord, I am claiming here, my lord. But those payments which were made, my lord, these are earlier, they are not included in these 12 cases, my lord. They are another 3 writ petition, my lord. These have been paid, my lord. That is not the question, my lord, regarding earlier 3, my lord.
How much you are entitled now?
Now I am entitled, my lord, as per our statement, it's 7 lakhs.
How can this court decide all these things?
Obviously, that cannot be, but if there is a dispute, they cannot be. But they, prima facie, my lord, they giving misinformation to the court, my lord. let them say, my lord, regarding these 12 cases, how much they have paid and how much they are going to pay.
They say that they have paid to you how much?
2,08,000.
70 plus 50, 120, 120, 183, 183 plus 15, 203, 2,08,000.
2,08,000, my lord, 50,000, 50,000, my lord, after the interim order passed by dishonorable court, and rest amount, my lord, these are earlier petition, my lord, earlier bill, not this 12 bill, my lord. Regarding this 12 bill, my lord, against this 12 bill, how much they have paid, they have not stated, my lord. That's why, my lord, I filed additional affidavit and reflected that. In fact, I have taken instruction from petitioner, my lord, petitioner also stated, my lord, and affidavit in our additional affidavit, let them, my lord, respond to our additional affidavit, which I have filed today, my lord.
How is the fees fixed out here,
My lord,
Mr. Goswami? How is the fix fixed? Where you issued an appointment letter?
yes, my lord, in respect of
Where is your appointment letter?
that is annexure A, page 11, my lord,
Yes, where is it?
page 11, my
Uh,
lord, petition.
to prepare the parawise comment as
With reference to
no,
sub-
no, no, no. For making payment in due course. Now, what is the fees, accepted fees? How are you saying that the senior advocate's fees is 6,000?
No, that, my lord, actually, look, I'll come. That letter, my lord, engagement letter which may not been annexed, my lord, but it has
Then?
not been. Let me give me some time and 3-4 days time.
These are all disputed questions of facts, Mr.
No, my lord, this is, so far is this 11 question, my lord, I will engagement letter, I will put this before your lord.
Hmm?
But they are not disputed, my lord, but they have, my lord, mixed up with the earlier payment and.
No, they have only paid you to 20,000 per case.
No, that is, my lord, decision taken afterward, my lord. My lord, my engagement at the time of, my lord, what I have to, my lord, take instruction on that.
These are not there on record. How can this court decide? How are you charging on the junior's fee?
My lord, naturally, he was engaged as a senior counsel, my lord.
So he should not have accepted it.
My lord,
And
yes.
how can there be a standing counsel, the senior counsel be a
But
standing
in
counsel?
that, in that mood, my lord, they have paid in earlier 3 cases, my lord.
They have paid, they were good, but can you enforce your right to get a fees for the junior counsel?
Obviously, a senior counsel cannot have paid without a junior, my lord.
So therefore, he should not have
And they should have
accepted it.
not been paid in earlier 2 occasions, my lord. Earlier 2
Therefore, a senior counsel should not accept it. Senior counsel has problems. If you are a senior counsel, you can't appear without a junior counsel. There's no quarrel. But if you want to be a standing counsel, the authority may, you have to delete, you have to give it from your own pocket. Unless it has been approved.
That, my lord, approved letter, my lord, probably, you know.
Because there has to be a fee structure which have to be accepted.
No, in
Yeah.
that manner, my lord, your lordship kindly see my affidavit in reply. And earlier three cases, my lord, without any hesitation, they have paid, my lord.
Where is it?
My lord, my affidavit in reply.
Hmm.
Affidavit in reply filed by the, my lord, that is page 6, my lord.
Yes.
That is this three bill, this total amount, my lord, is the three
Page?
page 6, my lord.
Yes, Annexure 1.
Annexure 1.
Hmm.
I am submitting the professional bill of 3 numbers of cases, including I and total amount of 3 bill amounting rupees 1,03,000. Advance payment of the advance payment 40,000 was advance, which shall be deducted. Accordingly, say that advance 40,000, total 3 bills 1,003 lakh, 1,03,000, and details in bill, my lord, at page 7, my lord. Appearance fees for senior advocate 6,000, junior fees form of 1,500.
Where is the senior fee?
Page 7, my lord.
This is for 34,500.
That is total calculation.
Ah.
So it,
Here the junior fees has increased from 1,500, which was earlier 1,000. What is your basis? The senior fees remains the instant
no, my lord, there is no junior fees at 1,500.
1,500. Kindly see here. Kindly see at page 20 of the writ petition.
No, that is 1,500.
Huh?
Junior fees 1,500. Page 20.
Show me how 1,500 is given. How every day hearing fees is given as 6,000.
No, my lord, if they are not agreed, then their earlier three questions, they should not have been paid, my lord.
Huh?
Earlier three cases, they have paid.
You
my
want to
lord.
return it back?
No, that,
No, you want
Yes.
to return it back, it is okay. You'll accept it.
that's my lord, defined question. My lord, your lordship kindly see it in,
Are you saying that there is an estoppel?
my lord.
Are you saying that there is an estoppel?
No, if
That they have paid the earlier fees, meaning thereby they are to pay again, whether without a fixation of the fees?
obviously, my lord, in my first case, my lord, they have paid in this mood, and definitely in second mood, my lord.
But
But
you,
assuming, my lord.
you are asking for a writ on the basis of a right.
My lord,
What is your right? You have to show it from some documents
But-
that this is your fees.
your
If
lordship,
you don't show it, can this court presume on the basis of estoppel? There's no estoppel against the state.
No. here in this case, my lord, what if your lordship, they have disputed, my lord, if regarding these 12 cases, which was, my lord, I raised the bill about only 12 cases.
Mr. Mohanta, I can only ask them to pay this 31,000 within a particular
No, my lord,
period,
that
that's all.
31, that, my lord, my whole case has been go. That 31, my lord, how they calculated, my lord?
Understood. Leaving the remaining amount, if
No,
you
my lord.
have any other further amounts, go to the civil court.
Definitely, I will go to civil court. But
Yeah.
my lord, if they, my lord, adjust my earlier payment, which was paid earlier in my cases, my lord, which is
No,
not.
no,
disputed,
you
my lord.
can raise all these issues before the civil
No,
court.
if,
How
my lord,
can this
if my
court decide?
accepted this one, my lord, then again they will keep, my lord, there will be stoppel, my lord.
For what?
No, if my accepted this 31,000, this was, my lord, I paid before this honorable court only for 12 cases.
No, no, Mr. Mohanta, this court will direct on the basis of their admission that they are liable to pay 31,500.
In respect of these 12 cases.
Whatever may be. They are saying that they are entitled, they say that they admit that another 31,500 is liable to be paid to the petitioner.
My lord.
Let them pay that. You have any quarrels out there, you can very well, I give you the liberty to approach the appropriate forum for deciding all this.
Definitely, I'll, what if they disputed it, but no, my lord, what I am going to submit to my lord, it is prima facie, my lord, they have done illegality, my lord, because those who are already
Now,
paid.
unless you show that this is a particular amount which you are entitled to on the basis of some document or anything, engagement letter wherein it has been mentioned that this is the fees you are entitled to per date of hearing, then this court can't direct otherwise. How can this
No.
court direct? Tell me.
At least, my lord, they should come before this honorable court that against these 12 bill, I have paid only, my lord, how much, this much? There is no affidavit, they all file on, my lord.
No, they have given it. They have
They have
paying.
given-
They
that's
have
why I'm
paid
trying
this
to clarify, my lord.
20,000, 2,40,000.
No, they, my lord, says about this amount, my lord, then I have to calculate 12 cases, but 15 cases, my lord. Those 3 cases already paid. I have not been, I have not included this in this petition, my lord.
No, Mr. Mohanty, here these are the 12 cases where they say in Annexure 1
My
of your affidavit that they are paying 2,40,000
My lord, as
Then
a
they-
whole.
as a whole. For these 12 cases, they are paying 2,40,000. Now, there is any other cases where they have not paid is another subject matter. It's another subject matter.
No, that they have been, they have.
Yours, I understand what is your submission. Your submission is they are giving this, showing this payment of 12, in these 12 cases, 2,40,000, but taking into consideration some payments which were made earlier.
Exactly,
That is what I understand that.
yes.
But whether it is so or not, how can this court decide? Tell me, how can this court decide? They are saying that in these matters, these two matters of the WPC number 2776, 2731, 2724, 27, all these 2016 matters, they have paid this amount. If you are entitled to further amounts,
In that,
claim some other
in
amount.
that case, my lord, in this other 3 petition names were not included, my lord.
They have not
mentioned, my
included.
lord.
They have not included that.
But
But-
not included, my lord, in the same amount in both the cases, my lord, both the bill, my lord, they have adjusted.
Which are the writ petitions which have not been included?
Yes, my lord, that annex, page, annex 1, page 6, my lord, that's now I have it, my lord.
Yes. Which are the cases?
WPC 6678, WPC 7168, and WPC, my lord, 6680. These are the 3 cases not included in the petition, my lord. Page 6, annex 1 of the affidavit,
Of your petition?
affidavit, my
No,
affidavit in reply,
affidavit in reply. Additional affidavit or affidavit in reply?
affidavit in reply.
Yes. Which under one? Which 6? Yes.
6678 WPC
Ah,
2015, 7168 2015, and 6680 2015. And these are settlement, these are paid.
these are the amounts where they have not paid.
These are the amount paid. That's why these are
But
not,
these have not been shown as paid here.
yes.
Understood? So these are the amounts.
That's why I am not included in the lead petition also. That this lead petition I have not claiming in the lead petition. Lead petition, that
So you are saying these 40,000, which is mentioned at page 6 of your affidavit in
My lord.
reply,
Hmm.
is the 40,000 which was paid in page number
no,
1.
30,000 was advanced and 103 also paid. That fee will-
Understood?
these
These
fee bills were separate.
40,000, you see, there's an amount of 40,000 paid here, page 69.
Also, my lord, other, your lord,
Understood? But this is a 40,000 which is paid.
my lord.
Is this the 40,000 which was paid in advance? Are you mentioning?
Advance in respect of these cases.
So these are in respect to these cases, but you have received the entire amount out here.
Yes, entire amount, that's why, my lord, these three cases,
So you are not asking for it.
I'm not asking for.
Now, are
But
these the,
that-
is this the amount of 163, the 1,03,500 included in this page 69?
yes, my lord,
Where is, show me,
that's why I'm filing affidavit, my lord.
where is it? This
No, that's-
1,03,500 have been included in page 69.
That will, my lord, they can be, they will, my lord, they can say it, my lord,
No, you are saying that 1,03,500 which you have received
my lord.
for in respect of other cases have been included in
Yes,
this.
my lord.
But here they have not mentioned about those cases.
They have not, your lordship kindly see here, they have stated in 12 cases.
And
They have not included in 3 cases. That those who I mentioned here, it is 3 cases. But payment which was made in 3 cases, they reflected here, my.
where? Are you saying this 40,000 is that?
Yes, my lord.
Because here you have received 63,000 by
That
check.
already that 1 lakh, the amount which they have paid, that is correct, that is been paid. That is 1,03,000, my lord, not.
Because these amounts were paid on 9/8/2017.
My lord.
Now, where is the amount here? It has been shown that 9/8, oh, this one, 63,500.
My lord. So that's why I'm submitting, my lord, if this, my lord, we are claiming 12, but there says that other 3 also, the payment made, my lord. So, my lord, reflecting that, man, clarifying that position, yes, I will, if they are not going to pay, definitely I ask my client to go to the civil suit, man. Definitely, if they disputed, man. But at that point of time, he, my lord, he was engaged, my lord, and probably in engagement, there's a resolution also taken, my lord, as per bill, you will submit it, they will consider. They will make the payment. Accordingly, these 3 payments were made.
No, unless you show that, this court can't act. Yes, when are you paying the 31,500?
2 months, sir. In 2 months,
What?
because there is no sanction from the lordship government.
We'll take it up next week. I want the payment to be made. 31,000. Get the check. Mr. T.J. Mohanto, the learned counsel, senior counsel appearing on behalf of the petitioner, submits that in the calculation so given on the last occasion, that the petitioner was entitled to rupees 2,40,000 for 12 cases, which have been enclosed as Annexure 1 to the additional affidavit filed today. The respondents have included an amount of rupees 1,03,500, which was actually paid in respect to WPC number 6678/2015 and WPC number 7168/2015 and WPC number 6680/2015, which is reflected from Annexure 1 of the affidavit in reply. It is the submission of the learned counsel appearing on behalf of the petitioner that the said payments so made earlier in respect to the above 3 cases have been arbitrarily and unjustly included in the payments in respect to the 12 cases as mentioned in Annexure 1 of the additional affidavit. The respondents are directed to file an affidavit clarifying the said aspect to the matter. It further appears that it is an admitted fact that an amount of rupees 31,500 is payable to the petitioner. This amount is payable in respect to cases done as this amount has been paid. This amount admittedly is payable to the petitioner for a long time. The ground of paucity of fund cannot be a ground to deny the petitioner the amount which have been duly admitted. Accordingly, this court fixes the matter on 11th of September 2023. On which date? The learned counsel, the respondents shall clarify the above aspects of the matter and shall also prior to that disburse the amount to the petitioner, disburse the amount of rupees 31,500 to the petitioner. So it is made clear that if the amount of rupees 31,500 is not disbursed, the respondents shall either disburse the amount prior to the next date fixed or produce a check in the name of the petitioner of the amount of rupees 31,500 on the next date fixed. It is made clear that if the said amount is not disbursed or the check is not produced on the next date, the Commissioner and Secretary to the Government of Assam, which department? The Director, Assam Minorities Development Board, shall be personally present in the court. But you have to go there, civil court.
Definitely I will go, but clarifying all this. But clarifying, after clarifying.
Timing item 12.
May I please, Lord, in this case, affidavit is ready, my lord, we have sent it for vetting, my
No, first of all, what are you doing with that pipe? Are you using that pipe?
my lord. We are using my lord.
If you're using the pipe, why have you laid the pipe in front of somebody's house like this?
Because my lord, at the first instance, my lord, it was tried to lay it down underground, my lord.
Then?
But my lord, there is a culvert, my lord, allowing the water from either from both the side, my lord. There is a culvert, my lord, and water allowing from both the side, my lord. And it was observed that a pipe shall obstruct the natural flow of the water, causing flood in the adjacent locality of Bhaskanagar and Sahab Tilla, my lord. That's why, my lord. That's why the first proposal was cancelled, my lord.
And what to do with the petitioner? Petitioner's house is blocked with your pipe.
My lord,
Can't take out the house.
The petitioner house is not blocked, my lord.
Why?
Because, my lord, there is enough space, my lord, to construct a gate on the compound of the petitioner, my lord.
You are filing the affidavit.
My lord,
When?
my lord, within 2 days, my lord.
2 days. Because last time you have taken time.
My lord,
We fixed the matter on 11th.
my lord,
Get your affidavit.
Right.
File your affidavit by 7th.
Right.
Ms. S. Sutiya, the learned counsel appearing on behalf of the petitioner, a respondent number 5, submits that she requires 2 days' time for filing the affidavit on behalf of the said respondent. This court fixes the matter again on 11th of September. The affidavit be filed by 7th of September without fail. It is further directed that in the said affidavit, the respondent shall also indicate a sketch map showing that the petitioner's ingress or egress to the land is not affected by the pipe standing in front of the petitioner's house.
Number 17.
Please, Lord. The next,
Yes, under what provision?
3A, my lord.
Huh?
3A
3A for what?
of National Highway.
Now you know. Acquisition done.
Lord. But in the notification, my lord, tract land has been wrongly mentioned as aggregation land in place of commercial.
Then what do you want?
Your lordship may be directed to correct notification, my lord.
No.
Without correction, the notification, my
You-
lord.
This is the notification.
Lord.
This is done under the National Highway Act.
Lord.
Where is your DAG?
Page 23, my lord.
Huh?
Page 23.
Page 23.
Annex of one, my lord.
DAG number what?
723, my lord.
723.
723, 720, 721, 722.
Where is it?
Page 23, my lord.
Page 23.
The type copy, my lord. And
Then you want to change the class.
Lordship,
Now what is written in your Jamabandi?
Lordship, which is file annex of 2, my lord.
Huh?
Which is Lordship, kindly see annex of 3, my lord, page 29.
Yes, what is it?
As per the order of Deputy Commissioner Nalbari by number 11/4/1994, my lord. The circle office of Boroma by number 7, the land measuring cube tester covered by tag number 720 is converted into commercial land from the arc land, and the same is recorded as separate tag number 7.
But Mr. Counsel, why should this court pass any order to that effect? You go and file, you have passed the order, no?
Yes, my lord, what happened? No order has been passed, my lord.
Till now, no order has been passed.
No, my lordship is under provision of section 1956. It is required under section P, notification was issued. Then thereafter land is shown as agricultural land. If he any objection to that effect, he can very well file TC under provision of TC can publish. It was no objection was raised. Thereafter declaration was made under provision of 3D. That is also shown as agriculture department. Thereafter, on the basis of 3D declaration, 3G under provision of value is determined, and accordingly payment was made to them. Already payment was made to them. Now,
So the order has been passed.
no, here I have detail affidavit.
It's okay.
Payment also
Now
has been made.
award has been passed.
But-
Now why are you then not going for an arbitration?
Kindly see, annex of 2, my lord. They have stated that I have not filed any objection before the authority, my lord. Kindly see, my lord, annex of 2, my lord. On 10/12/2007, my lord. A notification was published in the Doinik Agrodur on 25/11/2007, my lord. And in the Sentinel paper, my lord, 27/11.
Understood, Mr. Counsel, but you are to file an application under 3G8, 3G405.
Five.
You have to file an application, do whatever you read, then the competent authority will refer to the
My
arbitrator.
request is still pending, my lord. No order has been passed.
Have you filed an application after the order being passed under 3G?
No, my lord.
Why?
But thereafter, I have filed, my lord.
When was the order passed under 3G?
3G Miller that was on. I'll
Eh?
tell you. I have given a filed affidavit also, my lord. That was she was sent to her money was sent to the Kala that was on 13/10/2009. His name also reflected in that, because to additional deputy commissioner and NSA had sent the amount. But determine amount. My annexure 5, my lord, that is page 28, type copy, I have detailed type copy, 28, it is even, affidavit in opposition filed by NSA, my lord, that is, respondent number 2, one by Suresh Kumar. One Mr. Suresh Kumar has, also got it. At page 28, my lord, this letter, this is not clear, 29, your lordship will get it, their names are reflected here. Page 29, that is serial number 4, 41, 42, 43, 44, like this, it is already been paid to them. If their option. And that apart, NSA cannot do anything now, my lord, because this is land acquisition authority has to do needful, or arbitrator has to pass an order.
No, now the competent authority after passing the order is
Nothing.
functional official.
Because it is.
So
now-
there cannot be a direction to the competent authority. It is only through the land acquisition officer that these people have to do it.
Finally, after that, my lord,
The
Yes,
problem arises with all these things is, I don't know, the lawyers, they don't know or what. the provisions is not known. Why you are not filing? None of these people filed. Many cases of acquisition under 64. Nobody, they think that this court can exercise.
The problem
What is
is,
the power this court can exercise? Tell me. Now this court, let us assume, this court directs the deputy commissioner, okay, you correct, make it commercial. Then what happens? Tell me. Let us assume that this court had directed Ms. S. Borua that you correct and make it commercial. Then
which one is the my last?
Then who is going to pass an order for the purpose of the competent authority to pass the fresh order? Now the competent authority has become functions officio as per the provisions of Act.
Yes.
So the only way out is by moving the application and before the competent authority for making a reference. He will make a reference to the land acquisition, the lower division commissioner.
No, here now also difficulties also come, my lord, nowadays. But earlier, as per 2001 year, Lordship, remember, lower Assam commissioner was the arbitrator. Thereafter, now recently, last 3 months, all these commissioners' office has been dissolved. Now we are facing even problem because no arbitrator is there. Because that office itself been no
No,
more.
you can apply,
No, no,
and if
we are-
there is no
we are-
arbitrator appointed,
No, we are trying for that.
but
also.
if the arbitrator is not appointed,
Will be
because
used.
there it says that the provisions of the arbitration and conciliation
Yes, yes.
apply, you can approach this under section 11
Yes.
and get an arbitrator appointed.
Yes, sir.
But how can this court direct changing that now?
But they have not till today, my lord, they have not. But they have to file, he has to file.
Representation, we have filed a representation, several representation, my lord.
To whom?
There's representation still pending, my lord. Before this authority, my lord.
What did he say? Politician, representative politician.
Additional deputy, plan,
Want to pay?
page 72.
70?
If they, are-
He's
if
writing
the,
deputy commissioner. This is been written letter to, I think, deputy commissioner.
Land acquisition
Here,
office.
here deputy commissioner having NI Sec 1956, particularly DC is not aware. Right to fair compensation, it is DC has power. Now earlier before that, ADC is appointed, ADC is the power here.
There is-
ADC first ADC will come, then arbitrator will come, my lord. Then 34 will come, 37 will come, then Lord will come.
That's the land acquisition department is the. also-
Land acquisition department, no role is here. As per procedure of law, you have to, after against ADC, you have to write to, not to DC, you have to write to arbitrator.
very difficult. Every day I'm getting similar text.
Only difficulties, some difficulties are there, my lord.
No, no, in
Truly-
fact,
truly speaking, what happened?
in fact, what has happened is
Some,
people-
our honorable court heard some
they,
cases.
they,
it is-
they are not aware of that. Those people are not aware of that, and
Hmm.
the lawyers also, they don't properly advise. This is why it has happened. Where's the National Highways Act?
Asset
If
identity.
instead of this, they would have filed an application for the competent authority to decide, then would have been easier.
And their application is not proper, no, my lord. That is, that they are supposed to file, if at all it have been ADC also.
We
somewhat.
have the National Highways Act. Now read this.
PG,
3G,
PG 5. PG,
3G4.
thus notice shall state the particulars of the land and shall record on the person interested in such land to appear in the person or by an agent or by a legal practitioner referred in the subsection 2 of the section 3C before the competent authority at a time and place and to state the nature of the respective interest in such land.
Then 5.
Then 5. If the amount determined by the competent authority.
So the amount has been determined by the competent authority. Rightly, wrongly,
Not-
they have determined.
Not
Okay. Then
under subsection 1 or subsection 2 is not acceptable to either of the parties.
so it is acceptable to you?
I have received.
Is it acceptable to you?
No,
No. Then go.
the amount shall on an application by either of the parties be determined by the arbitrator to be appointed by the central government.
That is it. So it has to be done in that manner.
Okay.
Now tell me, once that order has been passed by the competent authority,
Okay.
can this court confer a jurisdiction upon the competent authority. No.
No.
Because the statute only gives the power to the arbitrator.
Arbitrator.
Then what to do?
Liberty, let it will liberty.
The instant writ petition has been filed by the petitioner. By the petitioner. Being agreed. By the actions of the competent authority under the by the action of the competent authority appointed by the actions of the competent authority in passing an order in terms with section 3G of the National Highways Act 1956 by showing the land of the petitioner to be as agricultural lands. A perusal of the writ petition revealed that pursuant to the notification under section 3A of the National Highways Act 1956, wherein the land of the petitioner was shown as agricultural land, the petitioner have duly represented before the office of the Deputy Commissioner. Which one? Deputy Commissioner what? Nalbari. Intimating that the land in question is a commercial land and not an agricultural land. However, nothing was done and the order was duly passed under section 3G of the National Highways Act 1956 by taking the land of the petitioner which have been acquired as agricultural land. It is further seen from the affidavit filed by the respondents of our NHAI that in the meantime, the order pursuant to the order passed under 3G of the National Highways Act, the petitioner have also been paid the compensation. It is, however, the case of the petitioner that the compensation so paid was not adequate inasmuch as the land, the classification of the land was wrongly taken by the competent authority. Taking into account the overall facts of the case, it transpires that the dispute arises as regards dispute which arises comes within the fold of section 3G5 of the National Highways Act 1956. As such, the provisions of the National Highways Act 1956 prescribes a particular course of particular course for ventilating the grievance by filing an application before the competent authority, filing an application.
For the arbitrator.
Before whom?
Arbitrator after this.
No, how arbitrator has not been appointed now.
No, now definitely this lordship passed order will do. Again, we are processing it. This arbitrator has to come. Will be now arbitrator only has to be because it is to be. We have to request them to government to be appointed because we have to write a letter. We are writing also letter. Definitely arbitrators will be required.
Before filing an application so that the said application can be determined by the arbitrator to be appointed by the central government. Taking into account the above, this court therefore disposes of the instant writ petition with a direction thereby granting the liberty to the petitioner to submit an application before the ADC revenue.
No, ADC Nalbari, who is the Kala, who is the competent for land acquisition, is to be written. Kala, who is appointed as a Kala.
Before the
Competent for land acquisition.
given the
ADC?
liberty to submit an application before the competent authority, that is the
ADC,
additional district commissioner,
Commissioner Nalbari.
Nalbari. ventilating the grievances as regards the compensation so paid to the petitioner. As regards the inadequacy of the compensation so paid to the petitioner, on the ground that the land which was on the ground that the petitioner's land was on the ground that the compensation was computed by taking into account that the petitioner's land is an agricultural land which ought to have been commercial land. The competent authority thereupon shall take appropriate steps so that the dispute so raised by the petitioner is referred to the arbitration by the central government. Accordingly, the instant writ petition therefore stands disposed of with the above observations and directions. It is further made that referred to the central government for appointment of an arbitrator. The same course of action shall be taken by the competent authority within 15 days from the date of submission of the application by the petitioner. The Union of India, who is going to appoint? Central government is Union of India.
Ministry of Road and Road Transport.
The Ministry of the Union of India represented the Union
Road
of
and
India,
Transport
the
Department.
Ministry of
Road-
Shipping.
No, shipping now it is not. Road and
This is
Transport.
what has been issued. The Ministry
Nowadays,
of
I
Shipping.
think bifurcated.
Huh?
It's Road and Transport now. It will be.
The Ministry of
Road and Transport.
the Union of India, Ministry of
Road and
Road-
Transport.
Huh?
Road Transport. Road and Transport.
MOT, na?
Huh.
Ministry of Road Transport
And Highways.
Highways shall thereupon within 30 days appoint the arbitrator so that the petitioner's grievances could be determined
No, not
with the above instant
or,
petitions.
or our only one line may I prefer lining one line. In this regard, NSI also, because our matter, NSI is also, redaction may be given to NSI also too, so that we'll also look into. Because
The-
then I can proceed further.
Further to that, it is also directed the National Highway Authority of India
Also
is also directed
to
to
look into
take appropriate steps
for-
in consultation with the competent authority upon an application being filed by the petitioner, so that appropriate steps are being taken for appointment of an arbitrator
Yes.
at the earliest.
Now it will be helpful for me. Yeah,
18. Yes, Mr. Borpuzari. Your matter. Yes, what happened? Any information?
Information, my lord. Awaited, my lord.
Eh?
Information is awaited, my lord.
None appears on behalf of the petitioner on call. Mr. Arbu Pujari also submits that he has no instructions in the matter. You have instructions
From SP, Superintendent of Police. we have received.
you have received? Show me that. Mr. Arbu Pujari submits that he has no instructions in the matter. However, Ms. S. Boru, appearing on behalf of the Superintendent of Police, have Baksa, has placed on record an instruction, parawise comments issued by the Superintendent of Police Baksa. Who was the person?
My lord, the brother of the petitioner,
What is the name?
my lord, the late Ghanashyam Brahma.
His body has been found.
Yes.
In the said instructions,
Lordship,
it appears.
Lordship, otherwise, please, my lord, to dispose, my lord.
I am disposing it
Yes,
upon.
my lord, relegating, my lord, directing the commissioner and secretary revenue department,
For what?
my lord, for payment of the, to examine and to pay to whether, my
No,
lord.
no, this will not be to the revenue secretary. This has to go under the victims compensation fund.
Yes.
Assam victims compensation,
No,
that scheme,
Since, my lord, the petitioner is founded on that notification.
1511.
1511.
No, no,
But
1511. When did this happen? This happened in 2002.
2002.
Then 1511 won't come in.
No,
That has to come before that.
My lord, the.
You will get
earlier-
only 1 lakh.
1 lakh.
But
yes,
here,
that's
I'll permit him to go to the DLSA, he will get 5 lakhs. Yes, then.
all. That is my lord's
uh,
magnanimity.
So don't let us
I
not do
cannot-
it.
I cannot.
In the instruction, it reveals that on 4/11/2002, the instant writ petition has been filed by the petitioner seeking a writ in the nature of mandamus, thereby directing the respondents to trace out the brother of the petitioner who was kidnapped and killed by the extremists on 3/11/2002, as well as for a writ in the nature of mandamus, directing the respondents to pay just and adequate compensation to the petitioner in the event of loss of life and or injury or loss that might have happened to the victim in the meantime under the notification dated 15/11/2014. The petitioner, however, is not represented. Mr. R. Bapudari, appearing on behalf of the Revenue Department, submits that he has no instructions. However, Ms. S. Borua, appearing on behalf of the respondent Police Department, submits that she has received an parawise comments from the Superintendent of Police of Baksa, Musalpur. From a perusal of the parawise comment, it reveals that on 4/11/2002, the petitioner lodged an FIR at Baganpara OP outpost, wherein he stated that his elder brother, one Ghanashyam
Yes,
Brahma,
Ghanashyam Brahma.
left his house on the night of 3/11/2002 at about 7 p.m. and he did not return back to his house. In the next morning on 4/11/2002, some villagers saw the dead body of Ghanashyam Brahma in the paddy field. On receipt of the said FIR, Borbari PS case number 81/2002 was registered under section 302. During the investigation, inquest over the dead body of late Ghanashyam Brahma, found lying in the paddy field with many injuries, was done by the executive magistrate and sent to the SMK Civil Hospital, Nalbari, for PM examination, for postmortem examination. Many of the witnesses were examined, but no clue. But the miscreants were found. No clue about the miscreants were found. It was suspected, as per the reports so submitted, that the NDFB and extremist group may have been involved in the crime. The case was ended in the FR by FR number 47/03, dated 31/7/2003. Next. Under such circumstances, the first prayer so made in the writ petition cannot be allowed, cannot be permitted, taking into account that the petitioner's brother's body have already been traced out. Now coming to the next relief so sought for, as regards the claim for compensation in terms with the notification dated 15/11/2014. This court finds it relevant to take note of that from a perusal of the said notification dated 15/11/2014, it has been mentioned that the compensation so payable as per the said notification would be
That will be 5 lakhs.
would be some victims compensation would be payable only in respect to incidents which have taken place within the state of Assam on and from the date of issuance of the said notification
Yes, ma'am.
dated 15/11/2014, taking into account that the amount that the incident had taken place in the year 2002, the question of the petitioner getting any compensation in terms with the said notification dated 15/11/2014 does not arise. Be that as it may, this court cannot be unmindful of the fact that a crime has been committed. Under such circumstances, this court, taking into account the provisions of section 357A of the Code of Criminal Procedure 1973 and reading the same along with the Assam Victims Compensation Scheme 2012, grants the liberty to the petitioner to approach the which district is this?
It will be Buxa. It will be District Legal Services Authority, Buxa.
No. Approach the Assam Legal Services Authority or Assam Legal or the District Legal Services Authority. The District Legal Services Authority, Buxa.
Buxa District.
Buxa. The chairman of the District Legal Services Authority, Buxa, in terms with the notification dated 18/10/2012, which is the scheme, namely the Assam Victims Compensation Scheme 2012.
Yes.
This court further, taking into account the provisions of clause 4 and 5 of the said scheme, directs the district, the secretary of the District Legal Services Authority, Buxa,
Yes.
to take appropriate steps upon such application being filed and pass appropriate orders within the period of 2 months from such application is filed. It is further directed that upon such application award be passed, the director of the Secretary, District Legal Services Authority, Buxa, shall forward the same to the Commissioner and Secretary, Government of Assam Revenue Department, Revenue and Disaster Management Department. The Commissioner and Secretary, Revenue and Disaster Management Department, upon receipt of the said award so passed, shall within 2 months therefrom sanction the new said amount and place and disperse the same to the District Legal Services Authority, Buxa, for onward dispersal to the petition.
Only one submission. It will be Commissioner and Secretary, Home and Political.
Oh, Home and Political. This is
Revenue
Home
will
and
not come into picture here.
This is revenue, no, Home and Political.
Home and Political. Offline.
Mr. Barbajari, I have got used to this, all these things. These schemes,
No,
where to give, where. Because here if I give, he won't get only 1 lakh.
no,
Yeah,
definitely.
it is 5
Otherwise
lakh.
also here, at the most, he will get only 1 lakh.
Where?
My lord, if this, my lord, scheme is applied into.
No.
No, earlier, my lord, it was 1 lakh.
Earlier, but here that is aspect is not mentioned.
No, therefore, if my lord has directed the petitioner, relegated the petitioner to the notifications under the revenue department. at the
Then
most,
1 lakh.
1 lakh. Now he is getting my lord 5 lakh.
Next.
That is my lord's magnanimity.
That is better, but. Itu কি হল? What is this again?
19 and 20, your lordship, both are same.
Relating to what?
In here, your lordship,
Extremists,
yes. One
ex
time,
gratia.
one time payment has been made, your lordship. But subsequently, the rate.
Oh, remaining 2 lakhs. Okay, dispose. Or similar orders. You are entitled to the remaining 2 lakhs. There is the order of Justice Bhuya.
Yes.
You have enclosed it there. এই সিসি বন্ধ করেছে যে কারণটা কি হেতু হেতু কেউ বন্ধ গরম পাইছে নে দত্ত Yes,
What is the non-payment of contractual bill?
contractual. PWD,
Yes.
which one? Who is to pay?
PW.
PWD. Period
2008.
8-9. No. Against work order of 2008-9. Why have you approached now?
My lord, they have approached the authorities, my lord.
No, why have you approached now?
So the completion certificate was issued
When?
in the year 2020, my lord.
2008?
Page 29, my lord.
Date?
30/12/2020, my lord.
What is the date?
And just above the signature, just below the signature, it's 30/12.
What is the date?
30.
Understood. Then thereafter, what is it? We are in years.
Then, my lord, statement of assets and liabilities was issued.
Huh?
Page 30.
Why there is no date? Who is appearing for the PWD? None appears.
Well, my
How much amount?
23,80,600.
How much?
23,80,600.
Why are you asking at page 32, 1,97,27,590.82? Who is appearing for PWD? No PWD council.
My lord, he has executed several other works, my lord, that include the other work order.
You are entitled to which amount?
That,
23,80,600.
yes.
Huh?
Yes.
23,80,000.
My lord, item serial number 3.
Huh?
Page 31, serial number 3, my lord. Yes,
Page 31.
special request to Keroni Road under Tengaka. The amount is concerned with.
No, but there is no date, Mr. Council.
There is there, but
Where is the date?
year is not mentioned, just below the.
We are concerned with the year. Why have you approached now? And are you saying that a work of 2008, the completion certificate has been given in 2020?
Yes.
My goodness, what has gone wrong with this? When have you approached? Show me. This court has to start with this. What is this 3 years? Nothing. You come just before it. No date.
Era 11, my lord.
You have approached at page 32. in the year 2021. Huh?
21. Before that, madam, I have explained in paragraph 11, madam. Paragraph 11 of my writ petition, madam.
Yes.
I have explained that
Where is it? The last representation was submitted by the petitioner on 3/3/2021
Yes.
for release of the outstanding, including the present bill. Then
before that, madam, I have visited the.
you have visited the office. How does this extend the period of limitation? You can't reopen something. We are concerned with, let us assume that 2011 to 14, 15 is okay. But 2008, they would not have any records also. Okay. Today you escape. Otherwise, it is the case of dismissal. None appears on behalf of the PWD on call in spite of an opportunity being granted. Full stop. None appears on behalf of a PWD on call. Full stop. There is no affidavit also filed. Although notice was issued as far back as on 25/8/2021. List the matter again after 3 weeks. Full stop. It is made clear that if no affidavit is filed or the counsel for the PWD is not represented, this court shall presume the contents of the writ petition to be correct and pass appropriate orders.
All right.
That's it.
Matter is pending, lordship, this matter may be taken with that matter. WBC 1763 of 2007.
Then
This matter may be taken with that matter.
you are evicted.
Lordship. Once evicted, lordship, then we have again settled.
You have again settled on that land.
Because lordship,
What is this?
lordship may kindly see, lordship,
What right do you have?
in the year 1995, we have submitted representation, lordship.
Hmm?
In the year 1995, we have submitted representation, lordship. Annexure F, lord.
Where?
Page number 96, lord.
Page number
96,
96.
lord.
Revenue Minister.
Lordship.
Then
Then lordship, thereafter, lordship.
how many
subsequently
people have signed it?
154, lord.
Only 2 persons is there.
So, one and 151
Hmm.
and 151 others.
Hmm.
And thereafter, lordship, the state has registered eviction case, and we have challenged that before the lordship, land revenue board, lordship, and the land revenue board passed an order at page 103, lordship. 103 page is 103, lord. Land revenue board passed an order, so we have challenged that eviction notice, lordship. Earlier we have been issued eviction notice, lord, and we have challenged that notice and before the revenue board.
Hmm.
And this board has passed the order in page number 103, lordship. The operative portion is 104, lordship, last paragraph.
Then what happened?
Then lordship, we have submitted this order, lordship, again, and our matters for settlement was pending, lordship, and during the pendency, again, 2016, lordship, this eviction notice was issued.
2000?
106, lord.
2000
2016, lord.
eviction notice was issued. Then
In 2016, lordship, page 106, lordship, and we have been evicted, lordship.
then
Since, and in this matter, in this case, lordship, we have challenged that eviction process, lordship, because since our case was pending before the deputy commissioner for settlement or allotment, lord. So we have prayed in this matter, in this case, lordship, for reconsideration of our petition for application for settlement. Eviction in the year 2016 happened.
They are evicted, lord. They are evicted from their lord.
Evicted.
in the year 2016 law.
Yes, yes.
They are no longer there.
Now we are there. Now we are here.
Hmm?
Now we are there. Lord. Again, we have settled at that place. And a similar matter is pending law.
Similar matter pending, this will be disposed of with that. But here is the thing that law is not in any way. What is there? Why are you approaching this court?
Lordship, because this eviction has carried out, Lordship, while this our.
No, why are you approaching this court? They can't do anything against you. You are challenging eviction notice of 2016.
And Lordship, subsequent action, Lordship.
Huh?
And subsequent action of that consequential or action, Lord.
What? You have been already evicted. Then again you have come back. So law is not there in your favor. You have taken the law in your own hands.
True, Lord.
So what do you want?
Now I want, Lordship, our.
That this court should protect your illegal possession. You have been evicted from government land. What is your right now? And do you have a right, tell me, to be allotted a specific plot of land?
No, I have no right, but they can consider for that because we are landless in this order also. and-
Landless people, it is there. You have the Bosundara scheme. Why haven't you applied there? What is this type of application before the revenue minister? Revenue minister, what does he have to business to do it? Can the revenue minister settle it?
No, Lordship,
Tell me.
Revenue Minister
Who-
cannot, Lordship, Deputy Commissioner.
Then why haven't you filed before the deputy commissioner?
Lordship, thereafter, Lordship, that.
There's an application, if you see section 4, rule settlement rules 4 and 5. There's a manner in which the settlement has to be made. Then you have not applied in that manner.
Have not applied for before Deputy Commissioner.
You see, nothing is required here. You don't need. You want to apply, you apply. You are in possession, they are not disturbing very well. You apply. Proper format. What is there to do this? This court, as of now, the eviction, you have challenged an eviction notice, whereby you were evicted. Then again, you have come back. Thereafter, they have not taken any action. Now, if I pass an order, I will say that the writ petition has to be dismissed. Would it be in your interest? Tell me. As of now, you have no right. If you don't have any right, neither you have filed an application in terms with the settlement rules, then what to do?
Since this revenue board's order
Revenue board's order is only remanding it to the nothing else.
till then, till date, Lordship, till 2016 also, Lordship, no action has been done.
No, nothing doing. They can't do anything against you. Which one do you want? Dismiss? Withdraw? Which one?
Then Lordship, will be allowed to withdraw with liberty.
You file appropriate application.
Appropriate application before the Lord.
The learned counsel appearing on behalf of the petitioner submits that taking into account that the petitioner pursuant to the eviction have again the petitioners herein pursuant to the eviction drive is again in possession of the lands in their occupation. The petitioner would not like to press the instant writ petition. He, however, submits that the petitioner may be granted that the withdrawal of the instant writ petition should not affect the petitioner's right to seek settlement from the government as per the present land policy. So, taking into account the above, the instant writ petition stands closed on withdrawal. However, liberty is given to the petitioner. However, it is observed the withdrawal of the instant writ petition shall not affect the rights of the petitioner to apply before the concerned authorities for the purpose of settlement made in the made in their favor as per the extant land policy of Assam.
Applies, my lord.
It's the only way out. Yes.
Lordship, this matter pertains to non-payment of contractor bill, Lordship. Very small amount, Lordship. Lordship, my case is that, Lordship, Pursuant to an NIT.
Yes, Mr. Upadhyay, what do you have to say?
Lordship may dispose of in the.
Verify.
Lord.
Verify, dispose, 3 months. Verify, dispose, 3 months, no, 6 months.
Got
No, verify within 1 month and dispose and make payment as per that considered.
Considered.
এটা আছে, irrigation department of
Obliged, Lordship.
তো খুদিলে পাবি। পারলে? Yes, Mr. Manik.
My lord, as early as 14th of September 21, the respondent were directed to give the status of. the-
Until further order, the irrigation shall not issue any work order in terms with NIT issued by so and shall not give effect to any such process on the basis of the NIT dated so and so. What?
It so
Does
happened.
the NIT remain further?
Lordship, my verbal instruction is not remain, Lordship, but I don't have the
That
written
if that is
instruction.
recorded, I have no objection. If that is recorded.
Lordship,
2021
Lordship,
NIT.
that is-
NIT was for what?
NIT was for, the
Solar.
solar part. things.
as per my
So what
instruction,
happened is that midway it was issued by the superintendent engineer, my lord, and the chief engineer had cancelled, directed to cancel it. Notwithstanding that, the junior officer proceeded with that. We came to the court saying that this is not done. The senior officer says something, junior officer
this
follow
matter
it.
in fact, Lordship, become instruction. He has also not do not have the instructions, Lordship.
It's very unfortunate for lawyers, my clients do not follow.
Huh?
It's very unfortunate for us. Clients on one hand, after they have some order process at some end, we don't have such kind of communication. So I readily cannot say, although to be fair, I also see that it should be infractions by Jaggi. But for me to make a stand, it's easy for him to take a call.
No, this is of 2020. 2 years have passed by.
In fact, Lordship, my verbal instruction is work has been allotted and the work has been completed also, Lordship.
What? In spite of a stay.
So he means to say by a separate tender notice.
But separate tender.
But that will also be difficult because on the word there is a stay.
No, there is not stay on the work.
The
Shall not issue in terms with the NIT.
Yes, the e-tender, Lord.
My lordship,
In terms
if
of
I
the
may-
e-tender.
NIT has been.
I understand. If I put it this way, suppose in a contested matter, not an uncontested matter, in a contested matter, this honorable court passes an order of stay legitimately after considering the materials on record and the arguments advanced and the pleadings made. Now, to escape and wriggle out from that and to come, not to come in the zone of contempt, they issue a fresh order. That is permissible. Then
permissible. Unless the court had stated that this particular work shall not be
I understand.
given effect.
Yes, Lord.
What is the work given? That any worker shall not issue any work order in terms with the NIT dated.
Yes.
But
That's all.
abandonment is also not before this honorable court. The
And they
abandonment.
must
of-
have abandoned
That's
it
what-
and
that's what-
issued. Because you were
I-
only agreed with the NIT.
So we were insisting for retender. Therefore, I would not be against the retender.
Yes, Lord.
Yeah.
But so far as the government is concerned, either they come up with a stand in one voice that yes, we have abandoned it, yes, we have gone for retender. In absence of that, they must come up with it.
Lordship,
You have got your verbal instruction.
Lordship,
On that, Lordship, so-
yes, Lordship, this is my verbal instruction, Lordship. Lordship may fix you after a week, Lordship.
Okay, list the matter on first. On 8th of September 2023, on which date Mr. N.M. Upadhyay, appearing on behalf of the petition, respondent Irrigation Department, shall apprise this court as to whether the said tender, which does as to whether the said tender, which is the subject matter of the instant dispute, continues to be relevant.
Lordship. Oblige, Lord.
Obliged.
I will check.
The interim order continues with it. There is an interim protection until.
Same order, nothing.
29.
Yes, what is the matter, Mr.
Matter is relating to the demolition issue, notice issued by the Naga Municipal Board. So I
You
have-
want
I-
demolition?
ah, so,
Demolition for what?
for unauthorized construction.
As to
Eligible.
why the aforesaid numbers of the demolition notices should not be set aside. Oh, this is the other way around from the morning. Now you want to save yourself. Okay. Yeah,
So here
challenging
my
the
learned
demolition.
friend told me that he had filed the affidavit in opposition, but
Ah.
I have checked that is not in the record. So this may be directed to place on record.
You filed an affidavit.
We have filed it, your lordship.
When? It is on record, something.
That is the
Okay.
month of February 2022.
Mr. S.C. Khan appearing on behalf of the respondent number 2 and 3 submits that an affidavit in opposition has been filed by the same respondent. However, the same is not on record. Lists the matter after matter on 5th of September 2023.
Our teachers' day is in our school.
Teachers' Day is 5th. I am saying about 25th.
Sorry.
25th of September 2023.
Of life.
30. The registry shall bring along, shall bring on record the date.
Up later.
Yes.
In this case, we have challenged the restrictive clause of the tender. And accordingly, we have challenged the tender and this honorable court has stated the tender for the year 2021-22.
Lordship, we have weeks time to file affidavit, Lordship. May.
Why is it? I don't know. A tender has been stayed out there. Tender for what?
Tender for
Micronutrient.
Huh?
micronet fertilizer. It
In
was
the impugn process, the procurement has been restricted to a particular class, namely the manufacturers, wherein the prevailing norms along with the manufacturer, various other entities were held to be eligible, which include the distributor. Has brought to the attention the action governing the which prohibits such an action, limiting. Now, what remains? What remains in this case? Tell me. A stay has been granted to a tender of 2021. Things must have changed in the meantime.
That's why, Lordship, the up-to-date status and Lordship may take it upon 8, Lordship.
Is the matter on 8th of September 2023, on which date Mr. B. Chaudhary, the learned counsel appearing on behalf of the petitioner, respondent PWD, Agricultural Department shall apprise this court as to what has happened to the said impugned tender dated 21/9/2021, which have been stayed by this court as on 22/10/2021. In time order, Pastor Leah shall continue till the next. 31. He may further obtain the necessary instructions in the matter.
Ma'am, please, your Lord.
Yes.
Not non-payment of contractual dues matter. Lordship, during the pendency of the rate, we have received almost 90% of the payment. But Lordship, in the final bill, at the time of payment, they have deducted security deposit. Lordship, the work was completed in 2018, bill was made in 19. Defect liability period was of 12 months. So why at 2023 they have deducted the security deposit? I don't know.
How much?
Security deposit amount of 2,76,300.
So you want only that amount?
Others, IT and all, we consider. Other deduction, taxation deduction, we have nothing to say. But as far as security deposit is concerned, that because our bill is at rest of the bill we have received.
So you are only concerned with the security deposit.
Lordship.
Remaining you have got.
We have
Here you are making a claim of 27,62,996. How much is the security deposit?
276,300.
276,300.
Lordship, this is the chart mayor submit.
Okay. Now, why they have not paid? And as per the contract, when it was to be paid?
Lordship, I filed an additional affidavit, but that is not on record. It was filed on May 2023. Lord.
May 2023.
But I have gone through the website. It has been uploaded only on 24th of August. Today I have checked on the website.
And what is your instructions, Mr. Yeah?
Lordship, Lordship.
Who is to pay you?
The irrigation.
Yes,
Why haven't
Lordship.
you paid that security deposit?
Lordship, that instruction I don't have, Lordship. I'm sorry.
Okay. Mr. G. Kandelia, the learned counsel appearing on behalf of the petitioner, submits though the instant with petition was filed claiming an amount of rupees 27,62,996. However, most of the part of the said amount have been paid to the petitioner, save and except the security deposit to the tune of rupees 2,76,300.
2,76,000.
Mr. N. The learned counsel appearing on behalf of the irrigation department shall obtain necessary instructions as to why the said security deposit had not been paid. List the matter again on 29/2023 on which
Obliged, Lordship.
the line Mr. G. Khandelia further submits that he had also filed an additional affidavit bringing on record the said aspect of the matter. The said registry shall bring on record the said edition.
Okay.
32. Yes.
It is your lordship. My lord, this is the classic case of how lands are being grabbed nowadays in city of Guwahati.
Huh?
How land is grabbed in city of Guwahati nowadays, my lord.
By whom?
By unknown settlers, my lord.
Then?
Your lordship will kindly see at page 22.
No, then what did you do?
My lord, the moment, my lord, we were holding a plot of land along with 11 families, including myself, my lord, in present where the Parsapara Stadium is now presently situated. It was assured that we will be given an alternate plot of land. Subsequently, we were given, possession were handed over to us. But since it was a shallow land, we only constructed the boundary wall and it was lying vacant. But suddenly, my lord.
No, you were given the land, settlement has been given.
So settlement has not been given, possession were handed over to us.
Possession is no business.
But my lord will kindly see page 22.
No, settlement has not been given.
Yes,
then what to do?
we have time and again wrote to the authorities to give us settlement.
Then what
In the
happened?
meantime, one person in the name of Mohan Paswan, he has came and occupied our plot of land. He's saying that he is the original owner of that plot of land and he bought this plot of land from one Sunil Boro at page 28.
Then?
My lord, subsequently we approached the commissioner of police. We wrote FIR, but nothing was done. In the meantime, we filed this writ petition.
Why haven't you referred it to the Land Grabbing Act Tribunal?
That the deputy
Yes. Why haven't you done that?
And my lord, since settlement, we are not the settlement holders, maybe that is the.
No, but you were handed over the possession.
Yes.
There is an encroacher in the plot of land, Lordship. We are sending him notice, Lordship.
Huh?
According to our last instruction, Lordship, one encroacher was there, Lordship. Subsequently, we have received a notice, Lordship.
There is an affidavit being filed by one Chinmoy Neo. Who is he?
He is the
Circle
circle
officer.
officer, my
What
lord.
does he say?
My lord will kindly see page para 6. With regard to the statement.
Handing over in
made in so-
pursuance to the government's letter dated so and so, Iman. The advanced possession of a plot of land measuring 1 Katha 10 Netha. And the soil is handed over in favor of Kumbur Musari.
He is the present petitioner, my lord. My lord will kindly see para 7. The
How much
petitioner
land?
allowed-
We are concerned, Mr. Counsel, how
My
much
lord,
land?
1 kotha,
10 Netha.
10 letters.
Then if the possession has been handed over, why you have not taken any action?
My lord, the circle officer has categorically stated that his group of miscreants showing as unregistered deed dated so and so, whereby it is stated that one Sunil Boro had sold the plot of land to one Mohan Paswan. In the records of the office of the circle officer, dispute reveals that neither Sunil Boro nor Mohan Paswan has claimed their possession over the said plot of government land. My lord, if it is a government land, how this is this sale deed that they are showing to us? This is a false sale deed, my lord. This is forged. And the circle officer has himself accepted that this is a government land and they are encroachers.
Yes, what action have you taken?
Last, according to our last instruction notice, we have 10 on notice. We have 10 on notice, one Raman Madahi notice, he is the enforcer notice. That is last instruction, 6 January notice, that is instruction is not executed.
Whenever you want to take possession, you exercise 18(2) and all these things. Why you are not being able, the police is not being able to take over? That's a government land which you have allotted to him. It's 6057, tag number. Why no actions have been taken? Or why you are not referring it to the land grabbing tribunal? And why you are not issuing, yes, revenue? Why haven't you issued this, the settlement order in favor of the petitioner?
That instruction we have written to them.
Why can't, why is the instruction awaited over 2021 matter?
We have written, but no
Whom?
to the commissioner. Twice we have written
Commissioner of,
to the principal secretary of revenue.
they have not responded.
No.
Mr. A. Bhattacharjee, the learned counsel appearing on behalf of the revenue department submits that on various occasions, communications have been issued to the principal secretary of the revenue department as to why the settlement order have not yet been issued in favor of the petitioner. However, no instructions have been received. List the matter again on 18th of September 2023. It is made clear that if no instructions is received on the next day, the principal secretary to the revenue department shall be personally present, personally present on the next day.
Deeply obliged.
A copy of the instant order be given to Mr. A. Bhattacharjee for due compliance.
33. So by last order, your lordship directed me to produce some with regard to service of notice, second notice. But if I require another
As to
further
how the
details.
notice was sent and whether there has a document to show that a notice to that effect was sent by way of registered post, and as to whether there is any postal delivery report in that.
If I require further weeks, they send me some record that is relating to earlier notice.
Huh?
Some record has been sent, but that was relating to earlier notice, not subsequent notice. But say a week's time may be allowed to.
See, on the last occasion also I had stated one thing.
Yes, sir.
Here he is claiming that you have done or not done with the notice.
Not-
Do it with the notice.
No, as per
What is wrong with it?
as per affidavit, notice was served on them. They said that they have not received subsequent notice.
You initially gave the first notice.
But
Thereupon you did not get any notice.
Further notice we did not receive.
That is what.
in paragraph 7, we have stated that notice dated 22nd.
That is why I directed to produce that.
Lordship, allow me a week's time, Lordship, I'll produce the entire original record.
What is happening is this unnecessarily, you are also not getting,
Yes, Lordship.
the matter is not ending because of this notice business. Only thing is the notice has to be given and give it. Let him, as he knows now, whatever reply or when you want to participate, that's all. Matter could have been thrust out
Lordship,
unnecessarily.
may we fix on 7th or 8th, Lordship, I'll produce that. On 7th or 8th may be fixed.
Is the matter again on 13th of September 2023. Mr. S.C. Kyle, the learned counsel appearing on behalf of the GST department shall obtain the necessary instructions, obtain the necessary documents as sought for by order dated 7/8/2023.
Much.
The interim order passed earlier shall continue.
Thank you.
Yes.
The morning report adjournment. Basically, Lordship, in this matter, we are trying to contact the petitioner, but we are not able to get instruction from the petitioner.
Yes, Mr. Bhattacharjee, you are trying to settle the land with them.
The affidavit has been filed, but yes, just now I have seen my lord. I could find it today, right now. I need some
You have
time.
filed affidavit.
Yes, yes.
Affidavit filed by respond number
This is by respondent number
6.
on behalf of revenue.
Respond number 6 affidavit filed long time back.
So this is filed on 16/3/23.
Hmm?
16/3/23 by Joint Secretary Dipankar Das.
Okay, there's an affidavit filed.
Yes.
The learned Mr. A. Bhattacharjee, the learned counsel appearing on behalf of the Revenue Department submits that an affidavit has been filed by the Joint Secretary Revenue Department on
On 16/3/23.
16
3.
2023. However, the said affidavit is not on record. Oh, there's one affidavit filed on 10/11/2023.
10/11.
কি ডেট লিখেছে সাকশন 2022
So 16/3. अपना कौन कहते?
The registry shall bring on record the said affidavit and list the matter again. You are enjoying an interim order? Are you enjoying an interim order? Ah. List the matter again on 4th of October 2023, along with the said affidavit.
35.
Lordship, I'd like to pray for an adjournment in this matter.
Withdraw.
Lordship, I would like to pray for an adjournment in this matter. The engaged counsel is suffering from conjunctivitis. Lordship, please just inform.
Yes, what is it? 2021, there is an order being passed that on the next day, the respondents in the DRI shall apprise this court about the status of the seized betel nut involved in the case.
Lordship, in this case, truck has been already been released. The goods that section proceeding is going on, Lordship. Nobody has claimed ownership till date, Lordship. This is my instruction,
And what is the petitioner doing?
Lordship.
You are claiming ownership over there.
Their period is
I have
for
no instructions, Lordship.
Huh?
I have no instructions, Lordship, with regard to this. I'm just appearing on behalf of the engaged counsel.
You are appearing for whom?
SS Zia.
Who is he?
She
counsel of the petition.
counsel of the petition.
He's suffering from conjunctivitis. It has been submitted to the bar that the learned counsel appearing on behalf of the petitioner is suffering. He is not being able to appear before this court on account of her illness. List the matter after 3 weeks.
Much.
This is Lordship. Here we are aggrieved by the issuance of Annexure 4, my lord, page 18.
Hmm?
Demolition notice, my lord, page 18, Lordship will find.
Yes.
My lord, what happened in this case, the petitioner, my lord, where the house she is residing, my lord, was constructed by her father-in-law.
Hmm.
And after her death of her husband, my lord, in the year 2020, my lord, she was maintaining, my lord, and looking after the property, my lord.
It is the construction site and found illegality in construction. Whether you pay to show need permission to the field. Therefore, when stop and discontinue the construction immediately, but you, in spite of the receipt of the order, did not comply. As such, we are hereby directed to demolish your own cost within 15 days. Okay, now you have a permission.
My lord, I'll place, my lord, in that was constructed by her father-in-law, my lord, in the year 2005, my lord, and they were residing there, my lord. And after her death of husband, my lord, in the year 2020, the authorities, my lord, on 4/5/2021 issued a notice that they have received a complaint regarding construction, my lord. 4/5/2021, page 15, my lord. My lord, on receipt of that, my lord, I received the state notice on 16/8/2022, and I filed my written submission, my lord. That is page 16, my lord. And lordship, at para 4 of my written sub application, my lord,
Hmm.
I have stated that no construction or renovation was not done, only a minor repair work, my lord, for passing of rainwater. And because of that, my lord,
No, you have a building permission.
building permission, my lord, I have stated that I could not find the building permission, but sketch maps are already there, my lord. And I produced them before the authority, my lord.
Yeah. You have obtained a permission from the Gram Panchayat.
It's a rural area, my lord. It's for construction.
So then, if it is a rural area, then the Silchar Development Authority would have no jurisdiction.
Yes, my lord, that is what we're looking for. my
Huh?
lord.
Are you saying that the Silchar Development Authority would have no jurisdiction?
To issue that notice, my lord, that we are looking for, my lord, and we got, my lord, one notification from the government website, my lord,
Ah,
regarding status of master plan, my lord,
ah,
as the Assam Town and Country Planning.
hmm,
That was, my lord, published on 6/5/2019, my lord.
hmm.
Present status I do not have, my lord.
Hmm.
In that, my lord, report, it stated that master plan for Silchar is under revision, my lord.
I'm not concerned. Now, are you saying that the land wherein you have constructed,
My father in.
wherever it is,
Yes.
have constructed, does not fall within the Silchar Development Authority?
My lord, that I have not,
Because
have
why you have then took the permission from the Gram Panchayat?
because probably, my lord, that at that point of time, it was Modhuban area, but the Panchayat area, my lord, to my instruction. It falls within the jurisdiction of Panchayat,
Now thereafter it has become within the Silchar Development Authority.
Silchar Development
When
Authority.
did you make the construction?
2005, my lord.
You made the construction in 2005.
Five.
You are,
I'm for Silchar Development Authority on behalf of Mr. S.P. Chaudhary.
your name?
K. Vishwakarma on behalf of Mr.
K. Vishwakarma. Mr. Vishwakarma, you do one thing, get your instructions as to as on 2005, whether that area fell within the ambit of your thing. Mr. K. Vishwakarma, the learned counsel appearing on behalf of the Silchar Development Authority shall obtain necessary instructions as to whether the area wherein the petitioner had raised, the father-in-law of the petitioner has raised construct, the area where in the had raised construction and the petitioner's building stand was within the master plan
Master.
of the Silchar Development Authority in the year 2005.
Ma'am, there is an interim order, madam. There is an interim order in this case, madam.
Okay, the interim list the matter again on how much time?
2 weeks can be.
Okay, list the matter on 27th of September 2023. Interim order passed earlier shall continue.
Obliged, ma'am.
37.
Your lordship may be pleased to look at order dated 14/8/23, where prayer was made for receiving instruction from
You
petitioner.
got the money?
Yes, sir.
1,50,000.
Yes.
We close it.
Yes, it can be disposed of.
Learned counsel appearing on behalf of the petitioner submits that the amount of rupees 1,50,000 have been released to the petitioner, which the petitioner have duly received. Taking into account the above, nothing survives in the petition for which the same stands closed. 38. Yes, what is your case?
Regarding my eviction, my already evicted.
You're evicted.
Yes, sir.
Then what happens? What remains? Why you have not been able to again get back to possession of the land? Huh.
Right to know in-
There was one case where the person concerned has been able to get back possession. Learn. You have been evicted. Nothing remains.
the director to file application before
You can always apply.
that observation everything.
Why? Tell me why. The learned counsel for the petitioner submits that the petitioner The petitioners have already been evicted by the respondent authorities from the land in their possession. And as such, nothing he therefore submits that the petitioner, being landless people, may be permitted to file appropriate application before the respondent authorities as per the extent land policy of Assam. Taking into account that the petitioner have been evicted from the land, nothing survived in the instant writ petition, for which the writ petition stands closed. Be that as it may, the closing of the instant writ petition shall not affect the rights of the petitioners to apply before the respondent authorities for consideration for land allotment if otherwise permissible under law.
Hello.
Orders.
On 15 to
2014 matter.
Yes, Your Lordship.
Yes, what is it?
Status report was called for.
Alleging kidnapping of his son on
Yes,
28th month at about a month. The learned shall apprise the status of investigation. Yes, what is the investigation? Anybody, any idea? What is the stage of investigation?
In fact, I'm handicapped at the moment. We have misplaced the files. If
Huh?
the petitioner may be in a better position to answer whether the child has been traced out. It is with regard to missing of a child, but I will try to figure out what exactly has happened with the file. But we don't have the file at the moment.
If the petitioner knew, the petitioner would not have done
No,
anything.
that was 2014. By now, already 9 years have elapsed.
That is the sad part. The petitioner herein has filed the instant writ petition. Taking a direction upon the respondent authorities to trace out the son of the petitioner, in respect of which Sonapur PS case number 392/2013 have been registered under section 365 of the Indian Penal Code. This code, by an order dated 15/2/2023, had directed Mr. S. Borua, the learned government advocate, to obtain the present status of the investigation. However, no instructions have been received by Mr. S. Borua as informed to this court. This is the matter again on 15th of September 2023, on which date Mr. S. Borua shall obtain the necessary instructions as regards the fate of, as regards the Sonapur PS case number. Hello, case number do the 40. none appears on behalf of the petitioner on call. It further reveals that no steps have been taken, as could be seen from the office note dated 3/8/2023. Taking into account the above, list the matter again on 11th of September 2023. It is made clear if the steps are not being taken and the petitioner is not represented, this court shall dismiss the writ petition for non-prosecution.
Your Lordship, the subject matter of this writ petition has become infructuous.
Miss, what is your name?
P. Gupta.
Huh?
P. Gupta.
P. Gupta. Ms. P. Gupta appearing on behalf of the petitioner submits why it has become infructuous.
Lordship, the subject matter of this writ petition was two properties of the petitioner were wrongfully seized by the local police on behalf of respondent number 7. However, the two properties that were in dispute in this writ petition, the petitioner is no longer the tenant of the said property. He has vacated the premises.
The learned counsel appearing on behalf of the petitioner submits that at the time when the writ petition was filed, that the petitioner was a tenant of the property and the seizure made by the respondent number 7 was put to challenge. However, in the meantime, the petitioner is no longer a tenant of the said properties, and as such, nothing survives in the instant writ petition. Accordingly, the instant writ petition stands closed as it has become infructuous insofar as the petition is concerned. 42.
May please, your Lordship. Lordship, in this case, the appellant, a petitioner has challenged the charge sheet as well as the FIR in which the CBI has investigated the case.
In
Lordship,
which?
CBI has investigated the case. CBI has filed a charge sheet and FIR, Lordship. Lordship, they challenged the crossing of the FIR and charge sheet, Lordship. This matter has been come after 2015 for the second time, Lordship. And on the last occasion, there was a direction to CBI to place all the material.
Was the FIR
as well as the charge sheet, Lordship.
charge sheet? What is the reason?
Well, the reason pursuant to the judgment of this honorable court, who is now pending before the honorable apex court, the Narendra Kumar versus Union of India.
Narendra Kumar?
Narendra Kumar versus Union of India. By this judgment, declared the CBI cannot be act as a police. They have no power to investigate the cases, criminal cases.
No power to investigate?
But this honorable court has
Without the
held that
consent of
CBI is
state
neither
government.
a organ nor a part of the DSP, and CBI cannot be treated as a police force constituted under the.
Where?
That judgment is under challenge in apex court, Lordship. It has been stayed, Lordship.
That judgment of Justice Ansari?
Yes.
Yes.
That judgment has been stayed.
Stayed, Lordship.
And there is a subsequent order being passed. Then what remains here?
Yes.
No, but the
That judgment has been stayed.
Yes.
By the Supreme Court. And there is also an order that the CBI can participate. And there is a stay to the proceedings.
Stay of
no stay
of
order.
this case, Lord, there is no stay order.
No stay order.
Then what remains? The charge sheet must have been completed.
Charge
What
sheet has
do you
been
mean?
filed, Lordship.
Justice has been filed.
Charge has been claimed, I think, if I'm not wrong.
Then
I don't know. I have.
well, why is this requisition pending? Why is the requisition? Your basic reason which have been given. In fact, I remember the Supreme Court had taken up the matter on an urgent basis, taking into account that there was the entire action of the
CBI.
CBI was nullified. And as such, there was an order stay, immediate stay being passed to the Tohara.
Right.
Then what remains?
Still pending there.
Unnecessarily pending out here from
But
2050.
this matter may be taken up from any other day.
Why?
Engaged counsel is actually outsider.
Who is the engaged counsel?
LS Chaudhary.
Huh?
LS Chaudhary.
LS Chaudhary. Who is he?
He is outsider from Delhi. That the matter taken up today has been listed for
filing of the affidavit, non-filing of
The
the.
rule has been issued. but no
Rule has already
affidavit has
been
received. Yes, no affidavit has been filed.
No affidavit has been filed, but Lordship, I have taken instruction. They are going to file the affidavit. Lordship.
When?
Very soon, Lordship. 3 weeks may be given.
How much time?
3 weeks time. 3 weeks time may be given.
I fix a date,
Lordship.
we file it,
Yes, Lordship.
list the matter on 5th, 6th of October 2023. The affidavit be filed by 27th of September 2023. The petitioner thereupon, the affidavit be filed by the respondents by 27th of September 2023. The petitioner thereupon would be at liberty to file the reply.
File it.
43.
May I please, Lordship?
Hmm,
In this matter, we are going to file affidavits today.
today,
Today.
Mr. S. Bulwa appearing on behalf of the petitioner, respondent number.
Respondent number 3 and 4 on
3 and 4 submits that the affidavit would be filed by the said respondents today. List the matter again on 27th of September 2023. What is the matter about?
Lordship, we are seeking cancellation of an OPC certificate issued to a fishery company. Lordship,
Hello.
this is a similar matter that may be tagged in along with this.
No, one matter is enough.
44.
Yes, what happened? What is the problem?
My lord, your lordship will turn to page 32. Page 32.
32.
My lord, I have narrated, my lord, in para 3.
That in page number 14 of the order need correction in WPC number, the party's name is written as Mohammed Sabit Ali and 78 other. It is necessary to reflect the name of all the petitioners of WPC. Otherwise, the petitioners will face the difficulties here. Where is it? 1916.
Now your lordship will be pleased to turn to page 46.
Hmm?
Page 46.
8, 40,
49. Last paragraph, link case, 1916. 1916 of 2016, Sabed Ali and 78 others.
no. এই বস্তুটো certified copy ওলালে নাম কেইটা নাহে নেকি এহেঁতৰ লগত এহেঁতৰ যদি আহে 2142 আহে এইকেইটা নাহে কিয় শুনা কমিটি মানুহ মাতক wait for some time let me inquire with the computer people what can be done because yeah and what is the other problem page number 15 of the common there should be
Page
a
50,
word petitioner after the word Assam in the
Assam.
second line.
page 50, my lord.
Page,
Here, nothing has been typed.
where?
Page
Page
50,
50.
internal page 15. 50. After the word Assam, petitioners should be there. Otherwise, it is incomplete.
Advocate for? No, Mr. What has happened, Mr. Sheikh?
My lord.
This is outside the control of ours. My control is only from 51 onwards.
My lord.
This is what is there in the computer. Let me ask the computer person. I've
My
come.
lord, your lordship would be pleased to see my petition.
Understood.
The
Understood
what-
everything.
What petitioners is to be there. Otherwise, it is incomplete.
Whatever may be,
Madam.
I'm only telling you, this is a defect of the computer. Let me just ask them. I've asked them to come. Because my area comes from page 51 onwards.
Now your lordship, another thing, the advocate on records are not reflected in page 50, my lord. Amar Chaudhary. Only Amar Chaudhary has come, M.A. Sheikh and other advocates' name is not.
This happens as per this only, na?
My-
This happens all as per the computer.
Yeah.
This is outside.
My lord.
Thing is this, my lord,
এই ওপৰত যে মোৰ এইটো অৰ্ডাৰ যে দিছো
as per-
এই ফাইলটো চাওঁ
as per our
file to-
writ petition, my lord.
এই
Otherwise, there is difficulty. my lord.
অৰ্ডাৰটো ক'ত আছে না, এইটো মেইনটো অৰ্ডাৰ মোৰ মেইন অৰ্ডাৰটো ক'ত আছে মেইন অৰ্ডাৰটো ক'ত আছে 9/8/2023 এই তাতে দে এইটো দে। Ha.
Main order
see-
was passed on.
No, 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 no. In the main order, your name is there.
My lord,
In my order, your name is there.
my lord.
এই বস্তুটো এনেকে নাহে নেকি খালি এইখিনি আহে এইখিনি টুকি নিদিয়ে নেকি কিয় নিদিয়ে এইখিনি নিদিলে এওঁলোকৰ নাম নাহিব নহয় no before no এইখিনি দি দিব লাগিব because I don't write anybody's name here এইখিনি নাম অহা নাই কাৰণে হৈছে Mr. Sheikh's name is here I don't read nowadays I don't write anybody's name so this is what it is there so এইটো freshly upload কৰি দিলে এইখিনি মানে এতিয়া দি দিব নে এইটোত পাৰিম নহয় না delete কৰিব নোৱাৰি he has taken certificate copy shall no, I'll pass an order shall again upload it now what has happened here আৰু এটা interesting ঘটনাটো হৈছে কি হৈছে এতিয়া এই গোটেইকেইটা পিটিশ্যনত এই ফাৰ্ষ্ট পিটিশ্যনখনৰ শৰ্মা নাটা হৈছে চাওকচোন এইবোৰত কি হৈছে এইখিনিলৈকে গোটেই পিটিশ্যনৰ নামকেইটা আহি গ'ল no problem এই লিংক কেছ যোনটো আছে এই লিংক কেছত এই ইয়াত 73 যে আছে তাহাঁতৰ নামবোৰ আহিব নেকি
722 it can be an asylum.
সেইটো থাকিবই লাগিব
722 of the
সেইটো থাকিবই লাগিব সেইটো চাওকচোন আৰু এইটোত হ'ল কাবেদ আলী আৰু 70 এহেঁতৰ নাম নাথাকিলে এহেঁতৰ প্ৰব্লেম হ'ব নহয় সিহঁতৰ নাম নাথাকিলে এহেঁতৰ নাম আছে এইটো কেছ এই কেছটো চবৰে নাম দেখিছে তো এনেকুৱাতো ইয়াতো নাম থাকিব লাগিব নহয় 19 কেছটো তাহাঁতৰ নামটো নাথাকিলে they have to approve how can you just তো এই বস্তুটো তাহাঁতে যদি চাৰ্টিফাইড হয় তেতিয়াহ'লে এই 763 লগত চবৰে নামটো নাহিলে কিবা চব কনফাৰ্ম কৰি Mr. Sheikh, tomorrow I'll take it up again. This one at 2. Why I'm saying is, if it is not there, that needs to be corrected. And then in the meantime, I'll pass the order. Okay, I'll take it up tomorrow. Because now if I pass an order, if that is not there, that needs to be corrected. This, don't worry, your name will be there. I'll put it very clearly out there.
Name of the petitioner. also.
Because what happens now, I don't nowadays put the names. It takes a long time. So I've asked them to put the slip and it is there in the main order. Main order it is there, but it is not reflected in the certified copy. I'll list the matter tomorrow at 2.
Obliging.
45.
My lord, the pension man.
Yes, why is this matter again coming before this court?
Order dated 21.
No, why this matter should come up before this court? This court, there's no further correction. A main petition won't go.
My lord, may I just make one small prayer? my lord?
Don't make any further prayer out here. This court has no business out here to take. It I commission hopefully to correction. Why this matter is before this court now? It's a pension matter. Isn't it? It's a pension matter. Then
Bench 2 matter.
Huh?
Bench 2 matter.
List the matter before the appropriate bench.
Okay, my lord, provisional pension is also not with it. If it is my lord, the
list the matter and taking into account that this court is presently not taking up the roster. Is taking up the roster of bench 5, list the matter before the appropriate court.
May it please your lordship. Lordship, these writ petitions have already been, lordship, amicably settled, my lord. And 2 writ appeals were filed arising out of this writ petitions, my lord. That has already been closed by the Honorable Chief Justice, my lord. The orders are with me, my lord.
আরে তো matter আছে নি, দুটো matter আছে, হ্যাঁ? দুটো matter। কোন দিকে না? আরো কোন লিখিত জন্য? Yes. কি আছে? কি একটা order দিয়েছে?
Orders.
Okay. Yes, what happened here?
Lordship, basically it is a matrimonial dispute arising out of
Yes. Where's the other side?
lordship.
Without the other side, it may not be proper, na? Mr. S.P. Sharma, the learned counsel for the petitioner submits that he would like to take first steps upon the respondent number 2 in WPC number 5424 of the learned counsel is given the interim order passed earlier shall continue. What is this interim order?
My lord, proceeding was instituted before the.
Yes.
Lordship, wait, please, my lord. May the matter be passed over for some time. The conducting counsel is on time.
Well, okay, I have only one more matter. After that, no more passport.
Fine.
One more matter. That's all.
My lord, this,
Yes, what is this? I
my lord, this IA is filed, my lord.
Huh?
During the pendency of the writ petition, my lord. They furnished a notice, my lord, saying that I have to pay rupees 36 lakhs or 24,000 something like bill, my lord, for total bill, my lord, which I have challenged, my lord. Already the matter I have challenged already before this court by you of this writ petition. During the pendency, they furnished this notice, my lord. So I have challenged this notice by you of this IA, my lord.
This is a writ petition filed for what?
Filed, my lord, I have challenged, my lord, in this case, in the year 2001, my lord.
What are you challenging?
Writ petition, my lord.
To rectify the lease deed by refixing the rent at 0 per order issued by the government, or to furnish fresh bill after revision of rent, to issue no objection to the petitioner for drawing up of the electricity, and to give effect of the order of revision of rent so and so in respect of the revision. So this is for revision.
This is a revision, my lord.
And what
Revision
is
of-
all these things for in the IA?
IA, my lord, during this pendency of this petition, they did not earlier furnish any bill. Now, all in a sudden manner, subsequently, they furnished a bill to me that I have to pay the huge amount of bill of rupees 36 lakh. Earlier, they did not pay the bill. I, my lord, approached time and again that after rectifying or after revision of that particular, my lord, rent, my lord, they have to furnish a bill with paper. Because it has been rectified, my lord, 6 paisa per square foot. They have to calculate it in this way. However, they furnish is rupees 35 paisa, my lord. This I have challenged before this court, my lord. But without rectifying, my lord, without reviewing, they have furnished this bill.
My lord, may I state the background of the case, my lord?
Huh?
May I state the background of the case, my lord?
Wait. Let me not proceed with you first. First, let me put a question to him. Mr. Counsel, tell me how this subsequent cause of action can be brought in the present writ petition.
My lord, this is not a subsequent one.
Absolutely.
No, my lord.
Okay, fantastic. If it is
Madam-
not a subsequent cause of action, then why haven't you mentioned in the first writ petition?
I have mentioned, my lord.
Now, have you mentioned about these orders?
Yes, my lord.
Show me.
In the writ petition, my lord, I have annexed the earlier orders, my lord.
No. Show me the order which you have asked for stay. You have enclosed 12/9/2022. 12/9/2022 order is where? Not in the IA, in the writ petition.
My lord, the writ petition, my lord, the writ petition is filed in the year 2017.
That is what I am saying. How by way of an IA in this writ petition, you could tell me.
The issue, my lord, lies on that particular writ petition. And writ petition is pending, and this is sub judice before.
But are you not, would this court have to set aside these notifications or orders or not? Can this court proceed without setting aside that order? Tell me. 12/9/2022, they have finalized and come up and say that you are liable to pay 36 lakhs or something. Do you agree?
Agreement.
Now, as of now, whether the adjudication has already been done as per what has been mentioned in the writ petition, you are asking them to revise and fix a rate.
So, my lord, I have been since in the year 2002, I am approaching again and again for him. Then after rectifying, you pay the bill, you furnish the bill, I will pay. That did not done. So I have approached before this honorable court by your writ petition. Without my lord going through this, without entering this issue, they furnished this bill 2020. So my lord, when the writ petition is pending, my lord, so I have filed this IA, my lord.
Understood, but isn't this a separate cause of action? Absolutely.
No, my lord.
Fantastic.
Separate cause of action, my lord. That the whole issue lies on this writ petition, my lord. Whole issue, my lord. That I have already approached before this court by your writ petition and praying to furnish a corrected bill, my lord. But they did not correct it.
They didn't correct it, they have issued their order. Now, without touching the order of the bill of 12/9/2022, can this court decide the writ petition? Tell me. Can it be possible?
This is right, my lord. But that is also under challenge, my lord, by your idea. That
Can you challenge it by an interlocutory application? How can you challenge it by way of an interlocutory application when it is not a part of the main petition? Can this court, by way of an interlocutory application, set aside a particular document? You may get a stay, that's a different thing. But can this court, in fact, the stay also should not have been granted to you. That is not a part of the petition.
But IA, my lord, emerged from this writ petition, my lord. Because
Yes, now tell me.
My lord, cases like this. My lord, in the year 2001, my lord, one lease deed was executed between the petitioner and the ASIDC for allotting a plot of land for setting up an industry, my lord. So, my lord, the monthly rent was fixed at 0.35 paisa per month. Thereafter, my lord, the petitioner per month, per square feet,
Ah.
and the rent was 0.35 paisa, man. Thereafter, my lord, they came up with some government letter saying that, my lord, the rent was revised from 0.35 paisa to 0.06 paisa, my lord. Then, my lord, they filed several representations saying that the bill has to be rectified. And, my lord, the lease, the terms of the lease said that, my lord, the industry has to be set up within a period of 6 months from the execution of the lease deed. Then, my lord, they, after submitting the representations, my lord, they stopped paying the rent and also did not set up any industry, my lord.
So when the lease was about to expire in the year 2011, my lord, they filed a civil suit before the court of Munsif, my lord, seeking the same reliefs, my lord, which they have sought in the petition, my lord, for declaration that the lease deed has to be rectified, and for declaration that press bills should be issued, and also seeking permanent injunction, my lord. That suit was dismissed. Thereafter, they came up before the court of civil justice, and that appellate court also dismissed their first appeal. Then, my lord, they filed a second appeal, my lord. In that second appeal, my lord, they prayed for withdrawing with a liberty to approach any appropriate forum, and that was allowed. But what happened, my lord, in this petition, my lord, the judgments of the lower courts were not challenged. Had the judgments of the lower court been challenged, saying that, my lord, they violated the fundamental rights of the petitioner, my lord, then that would have been a different chapter, my lord. But, my lord, since those judgment and decree of the lower courts were not challenged, my lord, they are now final and binding upon both the parties.
First and foremost, the appeal,
Yes.
it was withdrawn. The second appeal, if it was withdrawn, the withdrawal could have been only in respect to that appeal,
Yes, my lord.
nothing more than that.
Yes,
Because the courts does not exercise that jurisdiction.
yes,
The jurisdiction which is under 226 is a jurisdiction is different from that jurisdiction.
yes.
So then, so he is no case.
No, my lord, the issue
Okay.
involved have been substantially
No,
and
we
finally
dismiss the
decided.
case.
My lord,
We dismiss the
my
petition.
my humble servant.
No, you don't have a case.
While the matter,
Enough.
while the matter was before the learned court in view of second appeal, my lord, the learned court observed that this issue is not is a civil suit or is not issue lies in the civil suit or a civil jurisdiction. You may approach before the eighth court. The court observed that.
Not
Accordingly,
mentioned in the order, my lord.
also, my lord.
No, understood, but
court
whatever
find that
may be.
issue, my lord.
But did the court say that the suit, the appeal, the judgment and decree passed by the trial court shall not affect?
Not.
Or the first appellate court shall not affect? Then
Court says, my lord, you withdraw it and file it before the rate jurisdiction or before the rate. Accordingly, my lord,
if the court said to file a writ petition.
court orally says, my lord, it's a matter of rate jurisdiction. Orally says, also, my lord, it is not reflected in the order.
Ooh, where is that order? Let
Order,
us
my
see.
lord, page 80 in the rate petition.
Huh?
Page 80 in the rate petition.
Yeah,
82, my lord.
and accordingly the appeal is allowed to
Page
be withdrawn.
17.
Now we are considering the prayer of the present
Page
appeal and
17 and 18.
liberty to move any appropriate foreign subject to prevailing law. According to the dismissed on withdrawal. You have just withdrawn the second appeal, that's all. Want any relief out there, that the orders of the trial court and the first appellate court stands? You don't have a case.
Probably, my lord, it will be barred by res judicata, my lord. Probably.
When the trial court did not permit, even the civil court they have already decided that it cannot be, and you have withdrawn the second appeal. How can you file a writ?
My lord, this is the oral observation. My lord,
Anyways,
by the honorable court.
Anyway, today being the last matter in the day, I would not like to dismiss it. But you don't have a case as regards I'm not extending the interim order, not satisfied. Leaves the matter when you want.
Any date, your lordship.
You want.
So September 13.
Huh?
September 21.
21st of September. You wanted on a disposal. Chalo. But this matter does not require anything for disposal on a Tuesdays or Thursdays.
Otherwise, my lord.
You don't have a case.
Otherwise, my lord, I have
At
been
the
affected
request
by
of the
the
learned
rate.
counsel for a petition, a matter stands adjourned till 22nd of September.
Highly obliged.
Apply.
49.
Please, my lord.
Yes, what do you have to say?
My lord, this petition may be closed in terms of the writ appellate court's direction. I have a copy, my lord. In both the cases, the appellate court was pleased to pass to order.
What have you challenged here, mister?
My
My
lord,
lord, we come to page 23 of page item 48.
Item?
48.
Now tell me the repetition.
He has challenged the proceeding.
Mr. Ms. Choudhury, tell me which is the repetition, 5426 or
5424 of 21.
5424? Okay, which one?
Prayer is at page 23, lordship.
Page 23. Yes.
Written the nature of certiorari shall not be issued, setting aside and quashing the impugn proceeding, being NACT number so and so
Jalandhar.
against,
Okay, so nothing remains
nothing remains.
in view of the order passed in the
Yes,
writ
ma'am.
appeal.
Yes.
And the other one?
My lord, both the cases, the orders were passed.
No, no, in this case, what is the other one?
In 5426, my lord, the case was registered Amritsar. And on the
So
last.
both the orders, na?
Yes, my lord, both. They've been withdrawn. by the-
Etu Amritsar to etu likhibo dei. Enenge rakho. Heard the learned counsel for the parties, give your names. Taking into account the order so passed on 25/8/2023 in writ appeal number 6589/2022 bracket filing number by the division bench of this court. Nothing survives in the instant writ petition. Accordingly, the instant writ petition stands closed. Itu tibo enekwa writ eke order itu hol 54242 writ appeal number 6590/2022 filing number. Dated eke. ঠিক আছে? I stand.
You'll have to, not,